before the regular bench. Immediately after this, we see. It's not this bench.
Contempt application.
Yes. Call list.
Not information in the list. This regular.
কল করুন দাঁড়িয়ে আছি জলপাইগুড়ির ওয়ানটা আসেনি was issued. What was the contempt alleged?
Contempt. No.
Jalpaiguri is not appearing in the list. Whenever it comes, the supplementary list comes out, we'll take it out. Please wait. Yes.
My lord was if it rule issue.
What was the allegation?
My lord, the alimony which was directed to be given by your lordship, that has not been complied with in my contempt.
Yes, you are for the other side.
My lord, I am for the
Rule was issued. You are directed to be present.
Yes.
My lord, the advocate on record and arguing counsel is no.
Forget about them. What about the
My
contempt?
lord, the last order says that we cannot connect with my client, my lord. That is why the rule
Not
was
the
issued.
same thing.
So
But
what the arrest then against
I
you?
am sorry to say, my lord, the
My lord,
same thing.
he is 75 years old, my lord.
So what?
We don't know.
There are
we
more aged people in the
yes, my lord,
prisons.
we cannot contact him, my lord.
You cannot contact him. Why are you speaking for him? He is on a rule of contempt. He is to be personally present in court. He has been flouting the court's order time in and time out, and you're trying to defend him.
No, my lord, I'm not.
You cannot contact him. Forget him. We'll send him to prison. 75 years old. That does not entitle him to flout the court's order. Definitely not. You cannot take undue advantage of your age or your ailment or whatever, your gender, whatever. Cannot take undue advantage of any line of distinction.
My lord, may I respectfully submit one thing?
Yes.
My lord, I understand that she is a 75 years old.
No,
person.
tell us what. We don't have much
As a-
time on this bench.
My lord, the only thing is, my lord, as far as we could gather the information, the bank account is so poor as on today. The attachment of the bank account will even not do.
Withdraw the contempt. We will
No.
release this person, aged person. If he
My
doesn't
lord,
have
I
a
will
bank
be
account,
submitting, my lord, he has a
Sending
three-story
him-
building. Not let at least one floor of the building be sold.
first let him be produced by the police
Yes,
upon
yes,
warrant of arrest.
yes. It
In
happened-
view of deliberate and willful violation of the order of this court directing payment of alimony on the part of the contemner, a rule was issued which has since been served on the contemner himself on October 9, 2025 as it transpires from the office report dated October 29, 2025. Push of learned counsel having instruction to appear for the alleged contemner submits that he doesn't have any, you give your name also, that he does not have any further contact with the contemner despite his best efforts. Full stop. As such, it is apparent that the alleged contemner not only flouted the order of the court, but is nonchalant enough not to accede to the rule, and even after receiving the same, not to be present in court personally in terms of the rule. Full stop. As such, despite keeping in view the advanced age of the contemner, due to his recalcitrant action, we do not have any other option but to direct the contemner to be arrested and produced in court. Full stop. Therefore, a warrant of arrest do issue for the purpose of production of the contemner personally in court. Full stop. The matter shall next be listed on December 8, December 8, 2025 at 10:30 when the contemner shall be personally produced in court. Full stop. The order be communicated by the office to the officer in charge of the concerned police station.
Sonarpur.
That is
Sonarpur police station.
Sonarpur or Sonarpur?
No, Sonarpur.
Only Sonarpur.
Yes.
Check up.
Sonarpur. No.
That is the Sonarpur police station immediately for the purpose of compliance. Full stop. The matter shall next be listed on December 8, 2025 at 10:30.
I understand it is Sonarpur, but now it is Narendrapur. Now Narendrapur, your lordship will kindly insert. Now Narendrapur.
Sonarpur na kore Narendrapur. Police station Narendrapur. Next.
I'm great.
জলপাইগুড়ি ম্যাটার এসছে দেখুন এরকম ভুল হয় কি করে লোকে লয়ারে দাঁড়িয়ে আছেন কন্টিনিউ
Not I appear for the respondent.
টু টু যে কটা পাঠাটা আছে 2 to 15 একসঙ্গে দেখান
2 to 15.
these matters 2 to 15 are parted matters before us this bench we naturally we won't be able to take up this bench any further so we are cancelling the parted but directing all these matters to be listed in their original position that is immediately before the hearing matters now we
But
cannot
the
take the parted
item
matters,
number, but the
especially fixed
item
matters.
number,
These will retain their position in the regular bench
Before your lordship only or?
my lord, item number, my lord, item number 7. My lord, item number 7. My lord, item number 7, it's a specially assigned matter. Your lordship had heard me.
That intellectual property matter.
item number 7 is specially assigned to a bench presided over by me or
Yes,
the
my
bench
lord.
of Justice Kumar and me
Yeah, your lordship and Justice Roy.
Justice
Your lordship, it's your lordship, my lord. It is,
the bench presided over by me
yes, my lord.
so therefore I'll take up in the regular bench just now indicated Mr. Bhattacharya this will
My-
appear
my-
retain their position in the list
My-
regular bench.
This matter, you have heard this matter almost at the verge of completion of the hearing.
see we cannot form another this bench again
I don't.
for hearing of an
But
appeal
I
it's
know
not
that in fact
possible
this matter
if you want your matter to be prolonged indefinitely then we are retaining the parted and whenever we have the time
If I.
say in a year or so we'll take up the matter
Regular bench cannot be able to take up the matter.
we are repeatedly saying that why are you repeating it
No, my lord.
I don't think intelligent counsel should require more time than this we have repeated twice that we'll keep it in the same position the heading will be changed
But my lord, so far, I never 15 is concerned, that will be appeared before your lordship only. I don't know if 15 is.
what is the regular bench now
You before your lordship.
একটা অর্ডার প্রত্যেকটা আলাদা করে অর্ডার রেকর্ড হবে ইন্ডিভিজুয়াল
Item 3, but that was assigned cases by your lordship, both your lordship and Justice Kumar.
both of us
Yes.
are you sure
Yes.
My lord.
No,
No, no, no.
none of the matters have been alleged to two judges to
Your lordship was sitting.
bench presided over by me
Presided over by your lordship? No. Your lordship and Justice Apurva Sinara that heard the matter. Justice Apurva recently released the, he was on personal ground. He released. That is why you are assigned before lordship.
assigned before this bench
This year,
bench presided over by me
My
No,
lord.
this
My
bench.
lord.
this bench item 3
Item 3.
item 3 টা দেখি ফাইলটা
I,
your item
item.
My lord, I am for the appellate.
But can say, I may be wrong, my lord.
Let us see.
Four item.
Mr. Bhattacharya is so sure item 3 এর ফাইলটা দেন
Item 3, I am item 3. Day versus bond standard,
একটু দিদি।
item 3.
108 খানে হিয়ারিং ম্যাটার
Case has
আছে আপনারা
been-
এইসব ফাইল দিতে একদম ওই অ্যাসাইনমেন্ট অর্ডারটা বার করে দিন
Assign on
not you are a different matter please
Your item number is 2.
2.
Yes, item number 3.
Mr. Bhattacharya you are completely wrong
Yes,
item number 3 was assigned be placed before the honorable division bench presided over by me
yes.
I'm telling you.
none of the matters were assigned to both of us
Yes. দুই রিলিজ করে দিচ্ছে রেগুলার বেঞ্চে হবে। রেগুলার বেঞ্চে হবে।
এগুলোর মধ্যে
পরে আবার লিস্ট
কোনটা কোনটা পাঠার আর কোনটা কোনটা অ্যাসাইন সবই
My lord, item number 3 is পাঠান।
before the division bench presided over by one of us within bracket Sabyasachi Bhattacharya J. Bracket closed. Full stop. Although the matter was heard in part by the bench comprised of Justice Kumar uh,
Your Lordship, I'm suffering
of the
from-
present bench was
Bench
part
is
heard in
not-
part by the present bench, comma,
Is bench
in
is
view of the change of determination, comma, the part heard marking is cancelled and the matter is released from this list and shall be listed before the regular bench having determination, comma, which is also presided over by one of us within bracket Sabyasachi Bhattacharya J, comma, to be listed under the heading specially fixed matters before the other hearing matters. It will appear tomorrow in the list in its original position.
Tomorrow is holiday.
tomorrow.
Not
no,
tomorrow,
yeah.
tomorrow next. Yes. থ্রিটা ডেকেছেন?
Yes, I am for the appellant, my lord.
আচ্ছা, রাখুন। থ্রিটা তো অ্যাসাইন দেখালেন এক্ষুনি আমার।
Yes.
Justice
না, না, three হয়নি। ওর আলাদা আলাদা করে।
থ্রিটা তো দেখালেন অ্যাসাইন এক্ষুনি আমার। মিস্টার ভট্টাচার্য যেটা মেনশন করলেন, যেটা আমি এখানে রাখলাম।
Yes, I am for the appellant.
I am led by Mr. Bhattacharya for the response.
I am led by Mr.
এক্ষুনি
Bhaskar.
দেখালেন ওটা অ্যাসাইন। আবার বলছেন অ্যাসাইন নয়? সেম অর্ডার, হ্যাঁ, আগেরটা যা হলো এক্স্যাক্টলি সেম অর্ডার। টুমরো স্পেশাল ফিক্সড। কোড ডাকুন। 4-5 অ্যাকশন।
I appear for the appellant, especially assigned matter, same order.
অ্যাসাইনমেন্টের অর্ডারটা বার করে দিচ্ছেন না কেন? বলছি বারবার। এগুলো অ্যাসাইনমেন্ট ছিল, অ্যাসাইনমেন্টের অর্ডারটা দিতে হবে স্যার। এটা অ্যাসাইন নয়?
রেগুলার যেখানে এসেছিল
সেম অর্ডার, সেম অর্ডার। 6 ডাকুন।
I am for the petition.
টাইমটা বার করে রাখবেন ফাইলের পর। This was an assignment?
Not assignment.
Parted only. Due to change of determination, comma, let the parted marking of the matter stand cancelled and the matter be released from this list. First of the matter shall be listed on the next working day before the regular bench having determination under the heading specially fixed matters before the regular hearing matters. Next. দিয়ে দিয়েছি। আমাদের 6 নম্বর দিয়ে দিয়েছিলাম। 6 নম্বর অর্ডার হয়ে গেছে।
ঠিক আছে।
না, 6টা হলো 7 দিন।
আমি একটু লিখে দিই compare case number.
Item number 7.
Same, my lord, your lordship
Assigned-
will,
Assigned
right,
and parted.
yes, your lordship will remember that shape of bottle, Shaliman.
Yes,
Instead,
remember.
instead,
But
instead
now
of,
we are almost.
well, instead of Thursday, can it be on Monday? Because I have some,
Let it be
কালকে
in the list,
ছুটি।
Mr. Bhattacharya. If you have any difficulty, মেঘনাথ ওটা 1 নম্বরে যাওয়াটা হলো তাই।
My lord, we are supposed to make
Parted.
Grateful, my lord.
1 না 2 নম্বর। Assign parted. Thanks.
Grateful.
Let it be in the list, Mr. Bhattacharya. If you have any difficulty, tell the other side. We'll accommodate it. No difficulty. Next. Din, file din. Assign.
8, 9 assigned.
8 and 9.
এই তো
Assign.
No, my lord, 8 and 9 is parted, actually.
এই ভাই case number.
So far as my memory.
আর কিছু
দেখে নিন অ্যাসাইনমেন্ট অর্ডারটা দেখুন আছে কিনা।
Kindly check it.
Probably it is not assigned.
This is essential commodities, it was assigned.
Essential commodity, we did not have determination.
8, 9 when it was assigned, my lord.
We had determination.
At that time,
Right
at
now,
that,
that's what.
When the matter came up before us, so why are you saying it is assigned before us?
not assigned, my lord,
That
not assigned.
except for the minor was not there. That assigned, but it was due to.
এটা শুধু পার্ট হার্ডের যেটা সেটা
My-
not assigned. It will appear on the next working day specially.
My
Yes.
lords have been taking our privilege to appear, your lordship, my lord.
8, 9 same.
9 same.
8, 9 same. 8, 9 একসঙ্গে একটা অর্ডার হবে সিওটি। হ্যাঁ, নেক্সট 10।
এই নিন।
Thank you, my lord.
This must have been assigned.
a group 1 appeal, it was
Group
but
one appeal.
possibly not assigned. My
Oh, আচ্ছা।
possibly,
এটা অ্যাসাইনমেন্টের অর্ডারটা দেখুন।
possibly.
আমাদের determination ছিল না? We had determination to take up these matters.
Yes, then.
তাহলে শুধু পাঠাট করে দিন। Will appear on the next working day, specially fixed. শুধু পাঠাট এটা, দেখলেন? 12টা
11, my lord, my lord has got the determination. It was completed near, my lord, however, my lord.
only পাঠাট, not assigned.
It is, my lord has the
পাঠাটের যেটা সেটা, yes. 12
Okay.
দেখুন পাঠাট না assigned.
Advocate Abhijit Chakraborty is the.
Use the microphone, ma'am. Was it assigned to us?
Not it.
দেখুন।
May not have been. মনে আছে।
প্রথম 14টা ম্যাটারে ফাইল নিয়ে এই বেঞ্চটা বুঝবে আপনারা জানেন। ফাইলটা রেডি নেই?
Appeal against.
2 নম্বর কোডটা করে দিলাম
revocation of
আপনাদের জন্য
probate
ফাইল
matter.
রাখার জন্য। অ্যাসাইনমেন্ট কিনা
May
দেখুন,
not have been assigned.
চেক করে নিন। এটা it will appear on the next working day, especially fixed before the other period.
Number 13.
My lord, I am for the appellant, my lord. Pathad matter.
Pathad, whether it was assigned or not.
Not
assigned.
Only
Only
Pathad.
Pathad. Same one.
Pathad not assigned.
Pathad, only Pathad. Thank you.
I am for the respondent.
Was it assigned to us originally?
No,
দেখে নিন। Assigned not, only Pathad. Next working, specially fixed. 15 টা এটা 15 হয়ে গেল। জলপাইগুড়ি এখন জলপাইগুড়ি বলে দেবেন মুখে জলপাইগুড়ি, তাহলে ওনারা ইয়েস
এগুলো কবে থাকবে?
So Mittal, whether the other side is there, that is it.
Other side is there.
Just tell him. Mr. Chakraborty.
Mr. Chakraborty.
Why is he shying away? He is a contempt for the contempt.
Affidavit of service.
On this matter.
You are the contemptor or for the contemptor? Or both? দিন ফাইলটা কল করুন ম্যাটারটা।
Before my
ওখানে যা হয় মুখে কল করে দিন।
review.
গুড সাইড আছে এখানে দেখছেন।
Lordship, pursuant to your Lordship's order dated 22nd of September, we have served the alleged contemner and
No rule was issued.
rule was not.
So let us issue the rule.
This matter I'm led by Mr. Mujumdar. This is a GST matter where refund was my lord has passed.
We are directed refund.
Lordship,
It's refund.
and it's a 2022,
So that-
2022, the refund is due.
Why didn't you comply?
My lord, well, we have filed a review. Memorandum was filed.
When did you file the review? After the contempt or before the contempt?
My lord, it was filing date was 25th September
When did you get the copy of the?
and the registration was 18th October 2025 after mother service. But the filing, the process had started
When
on
did you receive the contempt?
10th October. My lord,
And
that-
you filed it
on 25th September. My lord, the-
before?
Yes, my lord, kindly see. And my lord, the difficulty was, my lord, the difficulty part was the memo was
Why
allowed.
didn't you
to,
mention the review
my
application?
lord, I was telling you, the memo was allowed to be filed from here.
Now it's regular.
Now what happened? The officer came down for stay the previous week. In the intervening holidays, he could not come. He came, my lord, then it was told that the file has gone back to Jalpaiguri. They will not allow to affirm it here. This has to go before the Jalpaiguri bench. My lord, now the process, my lord, yesterday.
We'll direct both the review and the contempt to appear together. December 8th is the next date fixed for another matter.
Lordship, contempt was filed on 9th September. They filed review on 25th
So
September.
the question is when they received it. We directed them to serve copy. They might not have known about the contempt when they filed the review.
Lordship, that Lordship did directed on 22nd September. After that only we served. That is
That is what, obviously you served after that, right?
They filed it after the 30 days limitation also. And there is no condonation.
No, we have, my lord, we have stayed.
Condemnation application.
Also,
I have not been received anything
No,
till
that-
today.
That is what I said. My lord, the stay and.
Learned counsel for the alleged contemptor submits that a review application has been filed. Whose of learned counsel for the petitioner in the contempt application contents that no copy of any review application or
Only
connected
the memorandum
application
has been filed, my lord. I would
has been served. Push up next para. Let the review application along with the contempt application be listed for hearing. Next on December 8, 2025 at 10:30. Push up. In the event any application is filed in connection with the review application in the meantime, comma, liberty is granted to the review applicant to mention the matter before our court officer for the purpose of inclusion of the same along with the review application. Full stop. Copies of the review application and all connected applications shall be served in the meantime on the learned advocate for the petitioner in the contempt application.
I'm grateful. The contempt matters are not.
No, Mr. Chakraborty, but
This is an important.
if you have not filed section 5, then it will be very difficult. You have to ensure that it appears along with the review. We have given you the leave, we ensure that it appears along with the.
Take me, there is a judgment of this division of our court. No, in connection with review petition, in connection with the
When we are hearing it, we'll hear everything. But please ensure that this section 5 appears along with the review application. Otherwise, we'll dismiss the review as time barred and just issue a rule on the contempt. This cannot be a ploy for stalling contempt.
It cannot be. It can be. By 8th one, everything will be regulated.
Yes. Taken in the regular bench. Call.
Yes, what I am mentioning.
You have come for mentioning. Yes. Yes. What is that?
Application.
Application, please hand over.
Regarding first appeal.
Application in a matrimonial appeal, Your Lordship.
Applications, please hand over, all of you. Mr. Mitchell, let us take the applications and order for tunes, please hand over. Other mentionings will hear. Application, order for tune, hand over without even mentioning. After that, we will take up the other mentioning. Mr. Shetty, you were mentioning application.
This is another first appeal.
No, those will take up. Mr. Mitra is also there, so we will take up the other mentionings now. You are mentioning something, you have mentioned.
For hearing, including in the list for hearing, my Lord.
What is this matter? Application?
No, for hearing.
Oh, then we'll come forward. Yes.
Well, I will not take a chance what he has said after I could make out. All I'm praying is that the tribunal hearing matters. Lordship, kindly, that's at the last. Any particular day, if your Lordship or sometime Lordship can remember that to give that above the civil on any day. I mean, sometimes, otherwise some tribunal hearings can also be very urgent and of pressing nature. So Lordship, that is after, it starts from 60 something and there are 60, from 68 it starts civil hearing, then then intra-court hearing, and it's been that way.
Intra-court, because intra-courts are shorter than the tribunal.
Scope is less.
But that's why. That is the only reason.
But intra-court normally Lordship disposes of first day. Normally Lordship.
Normally all the matters are disposed of apart from the regular first appeals.
That is
even some regular first appeals are disposed of, provided the council cooperate. Which you do. I mean, it's not an aspect. But Mr. Definitely then this week it's impossible because tomorrow is a holiday. Next week, next week we'll consider whether we can put on some day.
One day, any
one day, these matters. Definitely. একটু মনে করে দেবেন তো পরে যে আজকে যখন বিকেলে লিস্ট ছাড়া হবে তার আগে একবার মনে করে দেবেন যে ট্রাইব্যুনাল হিয়ারিং গুলো একদিন আগে উপরে আর একটা জিনিসও করা যেতে পারে ওই অল্টারনেটলি
I know.
Yes.
Mr.
Shen is a senior counsel.
By age.
Inclusion in the list for hearing, my Lord.
No, we are not taking it by default. What is the matter about?
One specific proportion.
Let us dispose of some appeals. Unless we dispose of some of the appeals, we cannot, which is the answer to Mr. Shen also, but he has a right of hearing, so we do.
This is one of the first appeal. This was appeared before the previous division bench.
Mr. Shen, we are not being able to add any appeal because at least some of the appeals, whichever slot we dispose of some matters, we are including matters in those slots. Applications, we are confident we will dispose of soon.
I have given one application.
The applications order for tunes.
I will pray at the time of hearing the application. I will make that.
Do that. But appeal hearings, please don't mention right now. I mean, right now is very vague, but let us dispose of some of the appeals. We'll definitely. Right now, no. Thank you for cooperating. Yes, call on the list.
Number 1.
Do you mention the convention? The office report indicates that not a single second judge's copy has been filed in respect of the memoranda and other papers of the appeal. Full the appellant is directed to file, the learned advocate on record for the appellant is directed to file second judge's copies of all the papers in connection with the appeal within a fortnight from date. Full the office shall furnish a further report either way within such period within 3 weeks from date. Full in default of compliance of the above direction, comma, let the matter be listed under the heading Lozima in the monthly list of December 2025. 2 সপ্তাহের মধ্যে ফাইল করবে, 3 সপ্তাহের মধ্যে অফিস রিপোর্ট দেবে, যা অফিস রিপোর্ট দিক ডিসেম্বর মান্থলি লিস্টে দিয়ে দেবেন লজিমা।
Item number 2.
My lord, I appear for the appellant. There appears to be
Section 5 is there.
No, my lord. Section 5 is required to be filed, my lord. I'm praying for 1 week's time.
Cannot block the list like this.
I'm sorry, my
You
lord.
should have filed a section 5.
Yes, my lord.
You didn't check up the stamp reporter's report also.
I checked it up this morning, my lord. 36
This morning you
days
should
of
have checked up
delay.
before mentioning, ma'am.
My lord.
No, this is not done. Let it go out of the list. You mention the section 5.
My
This
lord,
is a second appeal.
this is the first miscellaneous.
So we have determination of difficulty. There are other defects also. The names and other details of appellants are written in the cost statement. Could not be verified.
My lord, we shall file a fresh wakalatnama. There's also a
Not
defect.
only wakalat, yes, wakalatnama is one of the
Yes.
things. We'll grant you 1 week's time to correct the
Yes,
defects
my
and come back when you have the section 5. The appellant, the learned advocate in record for the appellants shall rectify the defects in the appeal within a week from date. Full stop. On the prayer of the appellants, comma, leave is granted to the appellants to file an application for condonation of delay in filing the appeal. Full stop. Let the matter go out of the list for the present with liberty to the appellants to mention the matter as and when such application for condonation of delay is filed. Full stop. You are appealing for the other side.
Yes, my lord.
A copy of the memorandum and all connected applications shall be given in advance to the learned advocate appearing for the respondents.
My lord, deeply obliged.
Take her
my lord.
address and whatever address
Yes, my lord.
and serve. Immediately when you file the section 5, mention it, will include.
My lord, deeply obliged, my lord.
Item number 3.
My lord, item number 3, this is the second appeal. Both the cases, my lord, state has lost. First, there is a point. Very good point.
Section 5 is also
Section
there.
5, 346.
What is the delay?
346. But there is a, my lord, genuine, my lord, kindly see my section 5.
Mr. Shengu, there are several defects also.
Defects, my lord, there are defects that the judgment and the decree, my lord, they are not matching. My lord, that's why, my lord, the report, kindly see the next page. It has to be rectified by the
In
learned
the
law
preamble
court.
also, name of the judge you have not given?
Name of the judge, yes.
No, suit you have not given.
Because
Appellate court judge, because the judge does not have a name.
the decree, Mohammad Reza, learned additional district judge. My lord, I have given
Civil
the
judge, senior division, second court, Barasat, you have not given the name.
Trial court.
The trial
oh,
court.
trial court time. Yes, my lord. My lord knows now
The other thing, plaintiff number 5 and defendant number 5.
my lord, now the judgment, in the judgment, there is something in the decree, there is some.
Mr. Sengupta, plaintiff number 5 and defendant number 1 in the certified copy of the decree, they are not parties to the memorandum.
Because, my lord, kindly see the judgment, my lord. I have looked.
No, we need not see the judgment. They were plaintiffs and defendant in the court below, plaintiff number 5 and 1, but you have not included them in the memorandum. You rectify the defects and come back. Rectify the defects. We'll give you 1 week's time. This will appear after 1.
My lord, opposition, my lord, if in the meantime, my lord.
Section 5?
Yes, my lord.
Then
Because, my
we'll
lord,
keep it after 2 weeks.
because, my lord, all my lord contradictory statements and, my lord, there is suppression of
Sorry,
material.
learned counsel for the respondent seeks to use an affidavit in opposition to can 1 of 2025. Push up next para. Accordingly, the respondents shall file their affidavit in opposition to can 1 of 2025 within a fortnight from date. Stop reply, if any, shall be filed within a week thereafter. Push up the learned advocate and record for the appellant shall carry out the necessary corrections to rectify the defects in the appeal in the meantime. Full stop. The matter shall next be listed in the monthly list of December 2025 under the same. Mr. Shengupta, please rectify the defects which you can.
Yes.
Give them copies and you have given copies. File.
I'm deeply.
Next. নট থেকে করবো কিনা সেটা আমরা বুঝি, একটুখানি আমাদের উপরে ছেড়ে দিন, কল করুন।
Item number 4.
It is pointed out by our officers that this matter has been sent erroneously by the department, although it was not mentioned by any of the parties. Full stop. Accordingly, let the matter go out of the list. Next.
Item number 5.
The opposite parties, my lord. Last occasion, lordship direct to serve the copy upon the, but till date the copy has not been served. We copy that.
হ্যাঁ সার্ভ করে দিয়েছি, দিস ইজ দ্য এফিডেভিট অফ সার্ভিস।
Okay, sir.
Yes. So what is the matter? Section 5 was allowed already.
Yes, yes. My lord,
You have already served a copy of the applications and
no,
memo.
my lord, my learned friend has said that.
I have already appeared, my lord. Kindly respond.
Yes, we are hearing it under order 41 now. Yes. You are appearing for the respondents.
Yes, ma'am.
Which respondent?
All, my lord.
Address us first, then write whatever you are writing, sir.
Yes.
Which respondent you are appearing for?
My lord, I am the
Only one. One is the only necessary party plaintiff. You are the defendant.
only.
So
Only
two
one-
we are
one
dispensing with service.
Service.
Two we are dispensing with service. You already served.
No, no, last of it.
Two was a pro forma defendant in the suit. You are a defendant in the suit.
Pro forma defendant is the granddaughter of the plaintiff.
Yes, we are dispensing with service. What have you challenged here?
My lord, the impugned order number 93 dated 19th of February 2025. The landed court below, while passing the order of injunction,
Yes.
did not notice that no prima facie case has been made out by the plaintiff while praying for an interim order. But the allegation is that the plaintiff is originally she was the owner of the entire property. Now the B schedule of the said property was gifted to me, the appellant before your lordship. And the C schedule of the property was gifted to her granddaughter. Now the registered deed of gift was.
You are related to her.
Yes, we had two daughters. Three daughters.
2 daughters, 1 son.
Okay, 2 daughters, 1 son. My lord, I am the elder daughter of the plaintiff.
Very.
Now, my lord, the landed court below.
One part, schedule B was gifted to you.
Yes, entire. And the deed of gift was registered. Suit was cancellation of the deed of gift. And a permanent injunction not to change the nature and character of the suit property. But the landed court below, even the plaintiff, while praying for an interim injunction, did not produce a single iota of document that I have used that my residential property as a commercial property. No, they even if they fail to produce any trade license, they fail to produce any such document wherefrom it appears that I am going to create a third-party interest.
So it was a blanket injunction creating third-party interest. Not only that, prohibited from giving effect to the impugned deed also, and doing any unlawful act. Regarding third-party interest, we are not with you. Third-party interest we may not create. But regarding the other two, what is your answer? It's a registered deed of gift. It's sub judice. Court will decide ultimately whether it is cancelled or not. Before that, at the injunction stage, how can they be restrained from giving effect to the gift deed? Yes, we will restrain them from creating third-party interest. That definitely you are entitled. You have filed a suit. But for the asking, they cannot be restrained from giving effect to it, thereby nullifying it at the injunction stage, at the ad interim injunction stage. We will modify this injunction order. We will restrict it to they will not create any third-party interest. The other part, unlawful act, not give effect to gift deed, this will set aside. You are disposing it off right now.
Kindly, my lord, directly serve a copy upon me. 1 day accommodation, I'll submit, my lord. 1 day accommodation.
The service has been completed. My lord, this
Memorandum you have served.
Memo. Yes, memo and the application.
Everything has been served on. We directed it to be served.
Last occasion,
Yes, we directed to serve the memo of appeal, and they have already served. Memo has been served on you.
My lord, last occasion, lordship direct to serve upon me, my lord. He is not served. Kindly, my lord, 1 day accommodation.
What not served? It has been served. You are saying telling a lie to the court.
No, my lord. Directly serve to the client, my lord. I don't have any copy right now, my lord.
That's your client's problem. We directed 1.5 months back. If your client did not serve, when did you serve? Let us see. We won't keep matters pending unnecessarily. No, no, they sent on 18th of September. Now we are on November, 4th of November. 18th of September served must have been served long back. Your client does not come to you. What can we do? It has been served. We will dispose of the appeal. Heard learned counsel for the parties, footstep, since questions of fact and law are involved in the appeal, we admit the appeal. Footstep, the point of the bone of contention in the appeal is brief. Footstep, in a suit primarily for cancellation of a deed of gift executed by the plaintiff stroke respondent number 1 in favor of the defendant stroke appellant, comma, the plaintiff stroke respondent number 1 sought injunction in respect of giving effect to the gift deed and creating third party interest. Footstep, by the impugned order, comma, the learned trial judge, comma, at the ad interim stage, comma, restrained the defendant number 1 stroke appellant from doing any unlawful act in respect of the suit property. Doing থেকে suit property double inverted. Suit property তারপর বাইরে double inverted. And
My lord,
from giving effect to the impugned deed of gift as well as from creating any third party interest in respect of the share or portion of the property mentioned in the deed. Footstep, next para. Upon hearing learned counsel for the parties, comma, we find that admittedly, comma, a registered gift deed exists as on today in favor of the defendant number 1 stroke appellant. Footstep, next para. A presumption of correctness to official acts is attached to a registered deed, and as such, comma, by restraining the appellant from giving effect to the impugned deed of gift at the ad interim injunction stage, comma, the learned trial judge has virtually decreed the suit in favor of the plaintiff at a premature stage without recording any concrete reasons for doing so and without granting any opportunity to the parties to address all issues by evidence. Footstep, next para. Insofar as double inverted doing any unlawful act, double inverted clause is concerned, comma, the said injunction is vague and there does not appear to be any strong prima facie case to the effect that any unlawful act is being done by the appellant. Even if some unlawful act is done by the appellant, comma, it is always open to the plaintiff stroke respondent number 1 to approach the concerned police station for taking appropriate action and or seek appropriate remedies specifically in that regard before the competent court. Footstep, next para. However, comma, with regard to creation of third party interest, comma, we agree with the view of the learned trial judge since, comma, in view of the challenge taken to the registered gift deed in question, comma, if third party interests are created, comma, unnecessary multiplicity of proceedings would ensue, which would or might render the suit infructuous. Footstep, accordingly, FMAT 290 of 2025 is allowed on contest partially, comma, thereby modifying the impugned order bearing order number 3 dated February 19, 2025, passed by the learned civil judge, senior division, first court at Baripur, district South 24 Parganas, in title suit number 89 of 2025, by setting aside the portion of the said impugned order whereby the defendant number 1 stroke appellant was restrained and prohibited from doing any unlawful act in respect of the suit property and from giving effect to the impugned deed of gift, but retaining the portion of the impugned order whereby the defendant number 1 stroke appellant has been restrained from creating any third party interest in respect of the subject property. Footstep, next para. It is made clear that we have not entered into the merits of the contentions of the parties, and it will be open to the learned trial judge to decide all issues independently in the final hearing of the injunction application and the suit without being influenced in any manner by any of the observations made above. Footstep, can 1 of 2025 is disposed of accordingly as well. Footstep, there will be no address to cost. Next. প্রথমে affidavit of service filed today be kept on.
Third party interest
No third party interest. Tenancy is also a third party.
because the allegation is that they have running a studio in that area.
Let them run it. Yes. Next.
Number 6.
Item number 6, my lord, Partha Pratim Roy is on his legs, my lord.
Nothing doing. You start the matter.
What happened is, my lord,
Report
The
on maintenance.
executing court attach the
You
proper.
have not given the valuation statement in the appeal. Vokalatnama is also required to be corrected. Name of the judge is, there are several defects in the appeal. Anandita, there are several defects in the appeal. The learned advocate and record for the appellant shall remove such defects within a week from date. Let the matter be listed next on November 10, 2025. Give your name, sir. Only your name, not Mr. Rai's name.
Number 7.
In item 7, my lord, I beg to appear on behalf of the
You're all on the same side.
No. Mr. goes with me.
This is a state's appeal.
State's appeal,
Yes,
my lord.
So, not appeal, I mean. Read. Yes. What is the matter, sir?
Here, my lord,
You are for the other side, respondent.
first of all, my lord, I am challenging the preliminary point, my lord, regard to my lord, mental limit of the way. Because there is a provision for appeal against the BLR order, straightway go to appeal.
No, notice challenge.
They are challenging the order passed by 14T, straightway go to, without availing the section 54 of the Act.
Was it taken before the tribunal?
Yes.
How was it dealt with?
yes, my
Mr.
lord,
Dave?
paragraph page 9 of the order.
You're ready with that point.
Sorry, my lord.
Let us see page 9 of the order.
ওখানে তো প্লিডিং থাকতে হবে, আনডিউ হার্ডশিপের কোনো প্লিডিংই নেই তো।
In 3, Uniform Sect 10 Criminal Act. Section 10, subsection 3B.
And this is not a good ground. Knock the door of justice, we can understand, but you must have. What happened to those? For the self-same cause of action, you took out so many applications. Read.
No, my lord, the tribunal was not.
Because it's a maintainability issue, we are hearing you first on this point only. If we are satisfied with your submission, we'll go back to them and hear on the merits.
But kindly appreciate one thing. The issue that initiated during the vacation, when the tribunal was not ceasing of the matter.
Understood.
Not I came before this honorable court. This honorable court directed that you approach before the court.
Right.
On the first day of opening of the tribunal, I filed my original application.
But why approach? What is the
Because my lord,
undue hardship of a higher degree? What is that has not been discussed?
what is the ad order that was challenged?
Order, it has been stated that it's of a higher magnitude, hardship of a higher magnitude. But what is that? That hardship has been expressed to be that you have moved a writ petition here and went there.
When we moved before this honorable court during the vacation, Xmas vacation, the order was not with us. Even we approached before the tribunal, the order was not with us.
That is not a hardship. You can go up in appeal. Why are you not confident in the appeal? If you lose the appeal, move the tribunal. Our general, it's a self-imposed restriction, as you know, well settled in several judgments. There is no bar as such. But definitely, why should you not exhaust the remedies? Both of you are deprived of one forum then otherwise.
Or maybe one humble favor. Would your lordship be kind enough to give me a day or two, 1 or 2 days?
No, we'll relegate it to we will give you liberty to file an appeal before the appeal.
Instead of may I get myself ready with.
No, you are sufficiently ready always. You are very sharp on these things. You do these matters, we know you.
There is no pleading about hardship. Lordship correctly says. Magnitude
no, the hardship given also is not a proper ground.
No.
We'll clarify that it's on a preliminary point only. We are not expressing our opinion on the merits of the case. Prefer an appeal, it will dispose of the appeal within a limited period independently of these findings. Either way. Learned counsel for the state stroke writ petitioner at the outset takes a preliminary objection to the impugned order to the effect that an appeal was available against the order impugned before the tribunal under section 54 of the West Bengal Land Reforms Act 1955. Next para. It transpires upon hearing both sides that the learned tribunal proceeded on the premise that no litigant can approach the tribunal under section 10 within bracket 3 within bracket small a of the West Bengal Land Reforms and Tenancy Tribunal Act 1997. But an exception is carved out in subsection small b of the said provision, where the tribunal may entertain the application without resorting to the remedial measures provided it would cause undue hardship, but it must be of a higher magnitude than a mere hardship, and there must be strong reasons. For sub next para, however, comma, while dealing with the issue, comma, the learned tribunal proceeded on the premise that the mere prior filing of a writ petition by the respondent in this court was the hardship. Full learned counsel for the respondent before us submits that initially no copy of the impugned order passed by the BL and LRO was available with the respondent, and the respondent had to move a writ petition before the vacation bench of this court, comma, after which the respondent was relegated to file an original application before the tribunal. Full next para. However, comma, we find that the mere fact that a prior writ petition was filed and the writ petition and the respondent was thereafter relegated to the tribunal does not create a jurisdiction for the tribunal where it is not otherwise available, comma, in the sense that it is the norm of judicial practice that all available remedies are to be exhausted under normal circumstances before the tribunal interferes into the matter. For sub next para, in the absence of any specific and categorical pleading or proof of any such hardship of higher magnitude on the part of the respondent to prefer a regular appeal, comma, we are of the opinion that the learned tribunal acted without jurisdiction in entertaining the original application and deciding the same on merits. Full stop. Accordingly, WPLRT 170 of 2025 is allowed on contest on the issue of maintainability of the original application before the tribunal, comma, thereby setting aside the judgment dated May 16, 2025, passed by the which bench is this?
Third bench, third.
Passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 05 of 2025 within bracket LRTT bracket closed, full stop. However, comma, it is made clear that this court has not entered into the merits of the respective contentions of the parties on the dispute between them. Full stop. Next para. Liberty is given to the appellant, respondent herein, to prefer a proper appeal before the appropriate forum against the order against which the original application was filed before the tribunal. Full stop. If such appeal is filed within a week, file it. Within a fortnight.
Well, I have to take instruction whether I have obtained the certified copy of the provision.
We'll give you back this set. No, that certified copy.
That certificate copy. What are the certificate copy? Yes,
We'll give you a fortnight. Within a fortnight from date, comma, the appellate forum shall decide the appeal upon giving adequate opportunity of hearing to all interested parties, comma, independently in accordance with law, comma, without being influenced in any manner by any of the observations made in this court or before the tribunal. Full stop. It is expected that such appeal shall be disposed of as expeditiously as possible, comma, preferably within 6 months from the date of filing of the same before the appellate authority. Full stop. No orders to cost.
Much wonderful prayer. Till the appeal is considered, there would be stay of that order because not kindly appreciate.
No. Pray for that.
Otherwise, not kindly appreciate.
After line at the liberty is granted to the respondent herein to make appropriate prayers for interim order before the appellate forum.
Or till past date of hearing, well, kindly appreciate. No. Otherwise, well, not.
In any event, you are not enjoying an interim order now.
There was an order that has been set aside, my lord. Otherwise, the
yes, now there is no interim.
No, otherwise, the process kindly appreciate.
We are holding in the same breath that it was not maintained. How can you grant an interim order here?
Not till such date is
no.
First date of hearing, my lord. Kindly appreciate.
Next. 8.
My lord, this is my application.
Yes, sir.
No, my lord.
So Mahato is there for the other side.
My lord.
Yes. No, my lord.
entirely challenging a demand, but the property vested under the Coal Mines Act 1973.
Coal Mines Act nahi hamaरे पास.
But I have annexed the Coal Mines.
You have
Act.
annexed? Thank
Yes,
you.
yes. Coal Mines Act I have annexed, my lord, that is at page 123. Right. If you also can you turn to section 3. Section 3.
Section 3 টা আছে হচ্ছে 127.
On the appointed day, this came into effect.
8.
My lord, relevant portion by 128.
Yes, yes.
But on and from 30th May 1973.
Yes.
Now, my lord, on the appointed day, the right, title, and interest of the owners in relation to the coal mines specified in the schedule shall stand transferred to and shall vest absolutely in the central government free from all encumbrances. Now, my lord, in the process, property was transferred in favor of the Eastern Coalfield Limited. I incorporated in the year 1974. Now, my lord, what happened? I made an application for mutating my name in the relevant record of rights, because which is mandatory. Now, my lord, when I made this representation, instead of rejecting my pair for mutating the name, what they did, they come out with a new story that this is a transfer, so you paid 49 crores and odd towards the transfer fees. Entirely challenging that demand, I moved before the tribunal. Now, kindly turn to my lord the tribunal order.
This act is one of the specified acts.
Specified act. Specified act. My lord, what happened, my lord? Initially the property belongs to New Birbhum Coal Company Limited. Admittedly, he was a Dakolkar. I'm not going into that whether the State Acquisition Act will apply or not. Your lordship knows that so far the Dakolkar is concerned, State Acquisition does not apply. So therefore, invocation of section 29 or 30 for lease, I'm not going into that. Admittedly, my lord, the property vested with the central government. And there is no dispute, there is no challenge to it. Now, my lord, then my lord, lordship kindly see, if your lordship kindly turn to the demand once, that is at page, at page 83. Page 83.
Your Eastern Coalfields Limited is an autonomous body. It's an undertaking, central government undertaking.
It's
what is it? Central government corporation.
Incorporated under the Companies Act. That I have stated.
So how was it given to you by the central government?
My lord, central government, this was transferred to the coal mines authorities. Then, my lord, if your lordship, sorry.
Transferred to the coal mine authority?
Yes, my lord, that is by a notification. That is at page your lordship will find at page 62. In term, Act provides so that the central government can. Page, my lord, 62. In exercise of the powers conferred under subsection 1 of section 5 of the Coal Mines Nationalization Act, such and such, the central government hereby directs that the right, title, and interest of the owners in relation to all the coal mines aforesaid to the section in section 3 of the said act, except the coal mines such and such of the schedule, vest in the central, vest in the Coal Mines Authority Limited.
Very good. Yes, yes.
Now, my lord, in the process, my lord, this was transferred to me, and there is no dispute to that. Now, my lord,
vested in you. The language of the statute is vested in.
Vested under the central government.
Yes. No, central government vested in you.
Yes,
that is language of section 5 and the notification.
Yes, yes.
Right.
Then, my lord, lordship kindly see, turn to my lord, the page 83.
Yes.
Now, this is the demand for the first time. Kindly mark to the subject. Transfer of 41.13 acres of government vested land at Mauja such and such. But I don't know, my lord, who is transferring in favor of whom. I have not asked for any transfer. This is a central government vested with the. Now, my lord, in the process, my lord, they have said that it is accordingly requested that on payment of, next page, paragraph 5, payment of 48 crores 97 lakhs 52,550 as transfer value by the government of India. The possession of the land may be handed over to the Eastern Coalfield Limited. But I am in possession. Everything is with me.
No, where is your letter preceding this?
Yes.
You sought for a mutation or
Sought for mutation
possession was handed over to you
by the center government.
already handed over.
Yes.
There is no question of giving possession to you.
My lord, because kindly turn to my lord that kindly see my lord, my letter for mutating my name.
Yes, where is that?
Yes. Page 81. No, sir. Can you give me 81. 81. There are so many representations before that. Huh? Yes. 65 onwards. Yes.
Who is this
65.
person? Rajbhushan Singh, who is he? 81.
Application for 81 is application for long-term settlement.
That person seeks a long-term settlement from Eastern Coalfield.
No, from the
That is
from
the
state
what
of
happened.
West
I tell you, lordship.
from
What
the
happened.
state of West Bengal.
I tell you, lordship. There was a meeting when, on the basis of my application, there was a meeting within the secretariat level. There, my lord, my representative made a mistake, because if land does not belong to the state government, then how may I put it to myself, my lord, how the state government can grant lease in my favor?
You asked for a lease.
Because before that, my lord, before that, I made an application for mutating my name. That is a mistake made by an officer. And for that manner, my right title and interest.
Have you ever withdrawn that?
No,
no,
I have not. I have not. But I have demand. I have challenged. Demand was made a challenge. I challenged the demand. My lord, provided.
Where is the mutation application?
Yes, mutation application, my lord. Page 65. The last paragraph, my lord, page 6. Further, in the previous few minutes, in the chamber of DLR of Bardhaman, it was decided that there is no ambiguity and dispute regarding recording A2 types of land. Hence, you are requested to please instruct the concerned authorities so that these types of land are recorded in favor of the ECL on production of the required document. Next, my lord.
It still stands in the name of the original owner, pre-vesting owner.
Not only that, my lord, what they did, some of the lands are given patta. I am carrying on my mining operation. State government has no right title interest over that. That's why I sought for mutating my name, because government is what is doing. Although I am carrying on the taking advantage of the non-mutating my name, they are granting pattas to the others.
Let us see how it was dealt with by the.
Yes. Now, my lord.
So mutation, that is not appealable if that is refused. Correction of record of right.
Mutation has not been done. No order has been passed. On the contrary, my lord, instead of refusing that, they sought for a demand on the guise of transfer of value.
So what did you challenge before the tribunal? The demand?
Demand. Only demand. Only demand. And except P10.
Demand is not under the Coal Mining Act.
No, demand, my lord, what I am said. That
you were asking, either you can challenge the inaction on their part in not mutating your name, or you can challenge the demand. Demand is not a demand under the Coal Mining Act, therefore no tribunal application is maintainable.
No, demand, yes.
Independent demand. A demand has been made that lease may be given if you pay so much, such and such.
Yes.
So how is that? I mean, how did the tribunal deal with it? Let us see.
Kindly give me just a second before your lordship. Another alternative, another PR is, my lord, that. না না মিউটেশন করতে টাকা চাইনি, ট্রান্সফার করতে টাকা চেয়েছে।
Mr. Arafin led you in the tribunal.
My lord, there is a direction for it. This is the letter
No.
of 2022. They approached before the tribunal in 2025, and there was a direction for affidavit, nothing more.
Because maintainability.
Because maintainability point, maintainability point has been raised.
When I requested the landed the government representative, you raised the issue because right of audience your first relies on you. Then he didn't make any submission. Only thing is this lot interim order refused. Now date fixed on 27th of April 2026, and affidavit direction was for within 6 months. Till that affidavit has
Mr.
not
Pan, let us see your prayer in the
yes, prayer at page
Wait.
42.
Page?
42. Page, my lord, 42, running page 42.
This is the interim relief. What is the main relief? That is the previous page.
Yes, relief. Page 41 on the last paragraph, 8.
So you are challenging the demand, the
Yes.
money demand.
Only demand.
How is that maintainable before the tribunal? Only that is challenged.
Only
No
demand.
non-mutation. Only that is and C is an order directing to
Yes,
mutate.
yes. That is my prayer.
But you cannot, for the first time, ask mutation before the tribunal.
No, my lord, the direction upon the concerned authority to mutate my name. That is the usual prayer.
Did you apply before the concerned authority for mutation?
Yes.
What is that application? You showed 65 or something.
65.
No, 65 is.
Page, Anasta, page 7.
Which page?
No, 65 is not that. It is addressed to the principal secretary. Principal secretary is not the mutating authority.
Exactly. You have never applied for mutation.
No.
Go and apply for mutation
There
independently.
is no application under
But, if your lordship kindly turn to page. কোনটা দেখাচ্ছিস?
No prayer for mutation before the mutation or correction of record of right before the BLL.
Before the BLR.
Addressing the BLR, I do not find that.
It's not there, Mr.
I do not find that.
So we can grant you leave to approach independently before the BLL. He can consider that correction of record of right.
My lord.
That in accordance with law he will do upon giving hearing to all concerned. And regarding this, we do not find this to be maintainable because the primary prayer is not maintainable on both grounds because there is no prayer initially before the PLL for mutation. For the first time, you cannot ask it before the tribunal. And regarding the other aspect of the matter, their claim, demand, that is not amenable to the tribunal's jurisdiction.
So in the
That is not under any specified act.
So, my lord,
If you want, we can hold the tribunal application not to be maintainable, give you leave to prefer appropriate challenge before appropriate court or
so far the demand is concerned.
before both regarding both we can give you.
No, can you grant me the
Demand will give you liberty to approach the appropriate forum.
My lord.
And mutation also to approach before the appropriate forum.
My lord.
And we'll hold from here that the tribunal application is not maintainable.
My lord.
Dispose of the tribunal application, relieve both of you from this agony.
My lord.
And some fees.
My lord, can you do?
Great.
My lord, may I have kindly, my lord?
Yes, but we may change our order.
Yes, my lord.
Even if Mr. Day is there.
They is there.
No,
Or half
please,
appearance of it.
Mr. Mahata, please go. Not difficult. Mr. Day is competent enough. We know that. Mr. Pan and Mr. Arifin, you can take your seats and Mr. Day, we'll just pass our order. If there is any factual incorrect statement, then just point out. The The present challenge arises against an order passed by the tribunal directing affidavits and refusing to grant any ad interim order in connection with an original application filed by the writ petitioner stroke Eastern Coalfields before the tribunal. Which of next para? It is contended on behalf of the petitioner, that is ECL, that the land in question was acquired by the government of India under the Coal Mines within bracket Nationalization bracket close Act, 1973. Thereafter, it was vested in favor of the Eastern Coalfields by the Government of India under Section 5 of the 1973 Act. Full stop. As such, comma, it is contended that there was no double inverted transfer as such in respect of the property in favor of the ECL at any point of time. Full stop. However, comma, it is alleged that when the ECL approached the concerned authority for the purpose of correction of the records of right and recording the name of the ECL in place of the uh, previous owner with regard to the said land, comma, instead of granting such mutation, comma, the respondent authorities made a huge demand of an amount of rupees 48, 97, 52, 550 from the ECL for the purpose of coal mining on the premise that the same was the transfer value of the property by the government of India in favor of the ECL. For some next para, it is contended that there was never any transfer within the contemplation of law and comma as such comma the said claim was palpably unlawful, which of accordingly the said demand notice as well as inaction on the part of the authorities in correcting the records of rights in the name of ECL was challenged before the tribunal. Full stop. Next para, learned counsel submits that the tribunal ought to have granted interim order semicolon, otherwise, comma, the challenge before the tribunal might be rendered infructuous if third party interests are created and or the demand made from the petitioner is implemented. For some next para, learned senior government advocate, he's the AGP, Mr. De?
Yes.
Mr. Mahathir is an AGP. Learned AGP appearing for the state submits that the original application is not maintainable since there was no application at any point of time for mutation or correction of record of right before the concerned authority under the law, that is the Block Land and Land Reforms Officer. For some next para, with regard to the demand in question, comma, learned AGP places reliance on a letter written on behalf of the ECL to the Principal Secretary, Government of West Bengal, seeking a long-term lease in respect of the subject property. Full stop. As such, it is contended by the state that in view of the long-term lease sought, the transfer value was attempted to be exacted by the impugned demand. Full stop. Next part, it is thus contended that there was no illegality on the part of the state in making such demand in view of the long-term lease sought by the ECL. For some next para, secondly, it is reiterated that the original application was not maintainable on either count before the tribunal. Full stop. Upon a careful consideration of the materials before us, we find that the two primary reliefs sought before the tribunal by the ECL were colon দিয়ে নিচে small a, that the demand of money made by the respondents from the petitioner be set aside, small b, that the petitioner's name may be mutated in the records. Full stop. Next para, insofar as the first claim is concerned, such demand was made apparently on the basis of an application for long-term lease made on behalf of the ECL, erroneously or otherwise, not coming within the purview of any of the specified acts as mentioned in the Land Reforms and Tenancy Tribunals Act 1997. Full stop. As such, no challenge lies before the tribunal on such count. Full stop. Next para. With regard to the second claim, since the petitioner ECL has not yet approached the concerned designated authority under the appropriate statute, that is the BL and LRO, there could not arise any occasion for the tribunal to direct mutation or correction of records of right for the first time. Full stop. Next para. Thus, the said relief was also not maintainable before the tribunal. Full stop. Next para. Hence, even without going into the merits of the contentions of the parties, we are of the clear opinion that the original application is not maintainable before the tribunal at all. Full stop, next para, thus, comma, to save both parties of long drawn unnecessary litigation and the agony of waiting for the fruits of the legal action, comma, we hereby hold that the original application, that is OA 1132 of 2025 within bracket LRTT, pending before the fourth bench of the West Bengal Land Reforms and Tenancy Tribunal, is not maintainable. Full stop. Next para. Accordingly, OA 1132 of 2025 within bracket LRTT is deemed to stand hereby disposed of. Full stop. Next para. The tribunal will pass consequential orders accordingly upon the basis of this order. Full stop. Next para. Leave is granted to the writ petitioner stroke ECL to approach the appropriate forum stroke court for challenging the demand of money made by the respondents against the petitioner ECL, comma, which was the one of the subject matters of challenge before the tribunal. Full stop. Next para. Also, comma, leave is granted to the writ petitioner ECL to approach the concerned BL and LRO to seek correction of records of right stroke mutation in its name. Full stop. Next para. If such approaches are made, comma, the concerned forum stroke court stroke BL and LRO shall decide the matter in accordance with law upon giving adequate opportunity of hearing to all interested parties independently, comma, without being influenced by any of the observations made above or the tribunal in the impugned order on merits. Full stop. Next para. No orders to cause service. Affidavit of service filed to be obliged. Thank you.
This is my application for restoration,
Restoration.
which was dismissed in a Lojima bench. In spite of my lord, several my lord, no,
What did you not comply with?
they are not complied with, but my lord, which was dismissed on my lord 20th February 2006, and application was filed, my lord, 2012.
Restoration application?
Restoration application is filed, my lord.
2012?
Yes, my lord.
Why 6 years delay?
My lord, one learned advocate was there. Thereafter, it is a North Bengal. It is actually he is residing in a remote village, and thereafter, my lord,
Such a remote village that it takes 6 years to come to High Court.
And with Section 5 application, I have already annexed it.
Section 5, we are nowadays very strict. Supreme Court is directing in every other matter, alternative matter. Some explanation has
in that means, during this time, my lord, application number 1 and 2 died. Interested in that application also before your lords.
What is the number of that application?
10919 of 12.
It has not been renumbered.
No, can number.
এগুলো renumber হয়নি?
Can number. Yes, my lord. That was the application was filed.
Have you prayed for setting aside abatement, condonation of delay into substitution application?
Substitution. And there are
go into the merits. There is no such merits even.
No, then this substitution application is also not time barred.
Time barred, but my lord, application was filed 2004. That was
when did the person die?
2004. Apply number 1.
2004 and 2010, and this application was filed in 2012. So long time barred. 2004, leave it alone, 8 years. 2010 also 2 years means much beyond 90 days. 90 plus 30 days, much beyond that. You have not even filed any Section 5 application. So long. Since 2012, we have crossed 13 years.
But my lord, it is
why did you file a Section 5?
I have leave to your lordship. Section 5.
Don't leave it to us, we'll dismiss it. You have no option but to leave it to us.
But my lord, your lordship can dismiss in Lojima. It was dismissed in Lojima bench. Your lordship can
substitution will be dismissed. So the Section 5, there is no Section 5. The Section 5 application will abate. Sorry, restoration will abate in any event. Can 10919 of 2012 is an application for substitution of the heirs and legal representatives of the original appellant number 1 Abdul Aziz and appellant number 2 Abdul Wahed.
Right.
Full the said deceased persons met their demise respectively on November 28, 2004 and February 2, 2010. Full next para. However, despite the substitution application having been filed long after the expiry of the statutory limitation period, till date, over the long period of 13 years from the filing of the substitution applications, the appellants did not find time to file an application for condonation of delay in filing the same and or setting aside abatement. Next para, as such, can 10919 of 2012 is dismissed as time barred. Consequentially, the connected restoration application, which is also not accompanied by any application for condonation of delay, is bearing can 10918 of 2012 also stands dismissed as time barred. Stroke abated.
Your Lordship can only to have the order 41 rule 11. However, if it is restored.
Since the appeal was already dismissed for non-compliance of the court's order, no further order need be passed in respect of the appeal. The appeal along with the above applications be reflected to have been disposed of in the computer system of this court.
And other minor application is pending, minor 10929 application for stay.
And 10920 also.
29 10929.
What is 10920?
Application for stay.
And what is 29?
What 10929 stay application and application for in connection with the appeal. Memo of appeal.
Can 10920 of 2012, an application for condonation of delay is dismissed in the light of the above observations. Consequentially, can 10929 of 2012 is also dismissed. No arrest cost.
Your Lordship can only to decide the order for 11, my lord. Both the courts, my lord, dismiss the suit as well as the appeal.
একটাই বলেছি যে
Appeal and also dismissed.
appeal was already dismissed. We said that. Yes, next.
Very unfortunate.
আমাদের ডিটারমিনেশন কবে থেকে আছে? Because just now I found out that 2019 onwards is our determination. Onwards মানে কোন দিকে? কারেন্ট পর্যন্ত না পেছন দিকে? Is 2017. Let the matter go out of the list due to lack of determination with liberty to the parties to mention before the appropriate bench.
2019 audit.
We are releasing on your ground because you are appealing. Because Mr. Bose is appealing. 11.
No one can match with your lordship's.
No one can?
No one can match with your lordship's cerebral.
Match means, is it a matchmaking game? No one can match means? Matching what?
Chauvian wheat, ultimately.
Chauvian? What is the spelling of Chauvian? And who was Shaw? Yes. Oh, Mr. Mukherjee, you were there. Then I would have detailed. Yes, Mr. Vasu. You are appearing in this matter also?
No.
You are appointing you amicus curiae in this matter. Yes, please call on. 11 you are appearing.
11.
Yes.
I'm appearing on two respondents. Two respondents I'm appearing. Others not served.
Others not served?
This is an application praying for injunction in connection with a suit which my client had filed. It was a suit for a declaration. I was the second wife, married by a husband after the death of his first wife. He executed a gift deed in my favor in 2009. On the basis of the gift deed, I got 2 decimals of the property which consist of a residential house. When I was not allowed to enter the property by the legal heirs, of the husband, I mean, the sons and daughters of the first wife.
First wife died or?
Died. She died in 2007.
Married there.
2009, there was a gift deed and the husband died in 2010.
So he married you after her death or?
Yes. In 2009.
9 married, 9 gift deed, then died.
In 2010, he died. My client was successful that way.
Yes.
Then, when she tried to enter the property, she was staying in the property, but when later on she went to some other place and tried to enter the property in 2015, she was debarred. She filed a suit for a declaration about her ownership right, and on that score, there was a challenge to the gift deed by the defendant.
Defendants are the heirs of the previous wife.
Now, the learned judge, was of the opinion that since exhibited the gift deed, Exhibit 1, but of the opinion that since there was a challenge to the gift deed, and I did not discharge Section 68 of the Evidence Act, therefore, my suit was dismissed.
Your suit was first?
That was the only suit.
No, you had filed the suit for declaration
of my right, in respect of.
They challenged the gift deed, you said?
In the written statement.
Oh, no.
No,
suit
not a different suit, nor by your counterclaim.
No, dismissed why? Injunction was...
No, it was dismissed because...
Suit was dismissed?
Suit was dismissed.
Because?
Because that Section 68, I could not prove about the acceptance of the gift deed after marking the gift deed as Exhibit 1.
But Mr. Mukherjee, that's relating to the evidentiary value, not admissibility. So,
True.
Even if it was marked as exhibit, you ought to have proved 122, 123.
I have by way of producing the document that my name was incorporated in the record of rights.
So that's an action
taken. That was an acceptance. Secondly, that it is also a prima facie proof of my possession of the property. So that was also
accepted your right on the basis of that.
Yes.
That was accepted during.
That was accepted.
So what is this application for?
So this is an application for injunction, so that the persons in occupation of the property, the respondents, they do not alienate the property.
Yes.
On the strength of their inheritance, claimed inheritance.
Yes. Don't alienate the property. You've already alienated the appellant, but don't alienate the property.
But other respondents is there.
You will direct service of copy. There was any caveat was there?
No, there was a Section 5 and pursuant thereto, a copy was right.
No copy of sir.
Section 5 voluntary service করেছে, Section 5 allow হয়ে গেছে।
No.
Allow
Section 5 has not been. When?
In 2018, my lord.
In 2018, that was allowed. She said. Yes, delay is condoned in terms of the court order. 2019, actually. Nothing to do. The present appeal arises against a judgment and decree whereby the suit filed by the plaintiff stroke appellant for declaration of a title on the basis of a gift deed executed by her husband was dismissed. Full stop, next para. The case of the defendants stroke respondents was that the gift deed was not duly proved to have been accepted by the donee during the lifetime of the donor within the contemplation of sections 122 and 123 of the Transfer of Property Act. Full stop, next para. Learned senior counsel appearing for the appellant submits that the gift deed was a registered deed which was marked as an exhibit. Full stop, moreover, comma, the very factum of mutation of the name of the plaintiff stroke donee in the records, comma, which was proved in the suit, comma, indicates that the appellant acted on the gift deed during the lifetime of the donor and took affirmative action on the gift deed by having her name mutated and taking possession of the property, which is substantiated by the mutation itself. Full stop, next para. Upon hearing learned counsel for the appellant and the appearing respondents, comma, we find that a sufficiently strong prima facie case for grant of injunction has been made out. Moreover, comma, from the pleadings of the injunction application, it is evident that the balance of convenience and inconvenience and the factor of irreparable injury lies in favor of grant of injunction. Accordingly, the respondents and/or their men and agents are restrained by an order of injunction from transferring, alienating, and/or creating any third-party interest of this in the suit property in any manner during the pendency of the application. The petitioners, the appellant shall serve copies on. You are for respondent number 1 and 2. Shall serve copies of the injunction application on respondent numbers 3, 4, and 5, indicating that the application shall be listed for hearing in the monthly list of December 2025, when an affidavit of service shall be filed by the appellant. Full stop. Copy of service of the application on the respondent numbers 1 and 2 is dispensed with in view of the appearance of the said respondents through their counsel.
Agreed.
হচ্ছে তো গেছে
কি পেপার ইয়ে আনাতে হবে law court record গুলো? May there be directions for bringing the law court records? This is the first step.
Will you direct right now because all are not appearing? Yes, we can direct because we are now the actor line at
কি করে এটা ডিপার্টমেন্ট?
we are directing the trial court records shall be brought by special messenger at the cost.
It's a legal matter. Let me just.
No, we can direct the
department go. The department.
Mr. Mukherjee, we can direct the legal aid. It's a High Court Legal Services Authority.
Yes.
We can direct
special messenger. That's the reason I am not.
Special messenger should.
That's the reason, Lord. I interject.
We'll pass usual order. Let the records be called for. Let the trial court records be called for in usual course. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to mention the appeal and the application as when the appeal is ready for hearing.
Okay. The department.
We'll come back in 10 minutes.
Yes.
My lord, the advocate on record of the respondent, Mr. Abhijit Chakraborty, is indisposed today because his mother's condition is very serious and hospitals also refused his mother's. My lord,
Hospital refused his mother.
actually, his condition very serious, my lord.
When should you take it up to us?
My lord, take it 1 week
Monday?
adjournment.
Monday?
One week.
Fair. An adjournment is sought on the personal ground of the learned advocate for the respondent. Footstep accordingly, let the matter stand adjourned till November 10, 2025. Please give your names. Don't give the name of your senior whose mother is it. Only your name. Yes. You can give all your names. You have not asked for adjournment. Mr. Shamul to থাকে generally. None appears for the parties at the time of call. Let the matter stand adjourned for the day.
Mr. Muller, I am for the appellate.
Yes. You're for the other side? Right. Yes.
Well, there was an application for attachment of the pension and his application for modification of the alimony.
Oh, not paying alimony. As per order of this court.
Yes.
I mean, or the High Court. Yes. The appeal is against what? Divorce decree?
Yes.
You are enjoying a stay injunction otherwise regarding
Yes.
marriage. Alimony, what was the quantum directed?
20,000
per month.
per month. Well,
Yes,
there
paid
were
up
some
to-
areas they cleared. Thereafter, again, there was a default. According to my instruction, as on date, my lord, September's alimony is due.
Only
They have-
September.
yes, yes. They have
No,
paid yesterday.
I have cleared all that.
No, yesterday they have paid 20,000 for this month, but the September, my lord, it has not been cleared. That is my specific instruction. Your lordship's view was that the modification application should be heard out unless
After
the,
the-
yes.
I have cleared all the area due.
What is the modification? Modification of the main order of alimony?
Alimony.
Yes. Move your modification first. September has been paid there, yes. Better thing to do. Mr. Rao should.
When my learned friend is saying, then I will have to clarify. But my lord, I took instruction yesterday. Maybe my lord, then I will see to it because one
Mr. Rao,
month.
because he has some papers, he can you can give.
No,
a-
no, I am not disbelieving him.
No, obviously nobody is disbelieving any of you. The advocates.
I took
why should you be-
instruction yesterday. There may be some miscommunication.
Both of you were. Yes.
I'm just going to.
You give a copy of this bunch
Yes.
to him. Later on, he shall clarify.
No,
During the
this
course
is
of the
the
day, give it. You
evidence-
can move your. Let him move his
Yes, yes.
modification first.
But
Yes.
this is the evidence in replies and the oppositions were not regarding.
Opposition, where is that? File.
Yes, yes, your lordship's direction was there.
This is
With
your
regard to his
opposition.
modification.
No, no, alimony application was finally decided.
Yes, yes, that was there.
This is reply and your file your opposition
This is my lord, yes.
to the modification.
Opposition to the modification and my reply, my lord, in connection with the application for attachment of pension. He
Oh.
filed an opposition and this is the reply. So everything is there, my lord.
Acha, fair. So modification, let us hear first. Yes, what is your move your modification application?
Because I have retired from service from the.
You are Mr. Bandyopadhyay?
Yes.
Yes, yes, Mr. Bandyopadhyay. Retired from service. What is your pension monthly?
30,069 per month after commutation.
Where is the document? In that respect?
Page 21 to 23.
কোন application বলো তো? Can কত? Can কত? Can 4 না?
Can 4.
Can 5 is the modification application.
Can 5.
At least in our copy, the original it's Can 5.
My lord, here is a click, my lord. If your lordship takes page 21.
Yes, 21.
This is the
We don't understand.
July. Yes. Basic pension 38,550. DNS relief 6,939. If it is clubbed together, it comes to 45,489.
So
Commuted,
38,000, where do you get it?
lordship. Page 21, annexure B.
Yes, 38,550, right.
38,550 and 6,939. The pension comes to 45,489.
Overdrawal is also there.
Overdrawal is zero.
No.
For
Overdrawal is zero, right?
my lord,
Commuted.
pension. Yes, here is the trick, my lord. He has commuted 15,000 and my lord made it, my lord, the total payable 30,000 and he is claiming that is
Commuted, what is the significance of commuted?
nothing, no reasons, my lord. He has not given such explanations. I have taken it in my opposition also, all these points.
What is the meaning of this commuted?
My lord, the lump sum amount after retirement which he got, my lord.
He took.
Once he commutes a pension to that percentage, my lord, he gets the lump sum amount. And that he has not disclosed. He has deliberately minimized the pension because he knows the consequences what will come.
No, you explain to us the significance of this commuting. Commuted means what is the meaning of commuting?
Bank loans.
No, commuting means what?
Actually,
15,420?
some percentage of my pension, I have selling out for getting that amount at a time. That is commutation.
You had taken that amount lump sum then at the time of your retirement. You have to disclose what amount was taken by you in lump sum. You must have kept in some bank or something. There is no trace about what happened.
Bank loans to disburse.
Bank loans is your personal headache. That's a different thing. But your basic pay cannot be adjusted with the bank loans. We can look into that for granting alimony, yes. But bank loan, why should you look into that? There is no child of this?
No child, no dependent also.
So 38,550 is the basic pension. And what amount was granted to 20,000?
20,000, that was at the time when his salary was to the tune.
30s.
In his affidavit of assets, my lord, he declared.
What was his salary then?
80,000 plus. He, as per his disclosure, it was 80,000 plus.
On the basis of 80,000, 20,000 was granted.
Yes.
So it should be reduced now. Now he is only, even if you take the basic pension to be 38,550, if he gives 20,000 to you, what?
45,000. 45,000 is the pension, my lord, if the commuted value is not taken into consideration. Because DNS relief plus basic.
Very well. 45,000.
45 and odd.
45 and odd. So it should be it should be reduced. I mean, 20,000 would be too much.
And my lord, let the appeal be also heard out, my lord, because my
Appeal is ready for hearing.
Yes, everything is ready, my lord.
Direct the appeal to be listed.
Lordship, because it was, my lord, permanent alimony of 5 lakh rupees was awarded. Challenging that, my lord, essentially this appeal, because there cannot be any, my lord, the marriage has irretrievably broken, to be very honest.
If that be so,
Yes.
then there will send it to mediation. It's a fit.
Mediation, my lord, was,
Failed.
Yes, it failed.
Who did not appear? Your client?
No, both appeared. My client will definitely appear.
Did
I can never be, I never do that.
5 lakh, I mean,
yes, his salary was 80,000 according to his disclosure at that point in 2022. He retired in 25.
So 5 lakh was given.
Only 5 lakhs.
But we have to look into the practical realities and take into consideration the current.
Take it into consideration.
Now his income is only this.
Now his income is this. But my lord, taking into consideration,
if you come to a consensus regarding the permanent alimony, then we can dispose of the appeal itself.
No, I am always
pending. Both
there
your clients are suffering.
Change of advocates, my lord.
7 months relation.
No, 7 months relation. There are
only 7 months.
According to together for 7 months. That is what is.
So therefore, there is no alimony.
He's not saying that.
Yes.
I mean, you should not carry the burden of that throughout your life.
That's true, my lord.
Monetary burden he has to.
Permanent alimony, my lord, 5 lakhs is very
5 lakh was sufficient. Why not sufficient?
My lord, 5 lakh, my lord, but she is 48 years old.
She was.
No, she is at present. The husband has retired. Her entire life is there, my lord.
So, but we cannot go on presumptions. Must have been some objective considerations by the learned.
That has to be taken, looked into.
We will list the appeal for hearing.
On the basis of
but for the timing, we will reduce the alimony. What should be the alimony according to you, Mr. Rai?
No, I leave it to your lordship.
80,000.
I cannot.
In ratio 1/4 was given. 80,000, 20,000 was given.
His affidavit of assets was of such a nature, the Honorable Division Bench was very much astonished. He said that his income is 81,000 and his expenditure is 1,25,000. That is on record. That is on record.
1,000 for agricultural income. And that
whatever. His expenditure was 1,25,000
for the month.
and his income was 81,000. So that was your lordship will find it from the judgment also.
Anyway, now even if you take.
Yes, my lord. I leave it to your lordship, my lord.
20,000 will be half. We'll give it, make it 10,000.
Yes, my lord. Half, my lord.
Deeply operational.
It would be half then.
Because, my lord, your lordship will also take into consideration he has commuted the pension with an ulterior motive. That is my humble submission.
No, then it comes to 45,000 about.
45,000 or not.
45,000.
And he has no dependent. Only the wife.
1/3 is 15.
Yes.
But I have some social duties.
Do your social duties. Do them without
I spent,
spending any money. Do your social duties. Don't spend money on your social duties. So 15,000, we'll reduce it by 5,000.
Deeply obliged.
Around 12.
Attachment will
12,000.
put on hold because they are paying now.
Yes, that is already there.
Attachment will
the last
dispose of.
occasion
If they
also
are
you have
paying,
mentioned
the
no,
attachment.
no, on the last occasion, your lordship, your lordship
They're paying.
heard that matter. Yes, now they are
12,000.
paying. After the
So
application
dispose
was
of
filed.
attachment also direct the appeal to be decided, to be listed.
Yes.
Can 4 is the attachment application? Yes.
My lord, it can be 12,000.
Can be 12,000, but we'll grant 15,000. Can be 10,000, 12,000, 20,000 itself, but we'll make it 15,000. Affidavits in opposition and reply filed to be kept on record. Full stop. Next para. It transpires from the application for modification filed by the husband in respect of the alimony order dated April 4, 2024, that in view of the subsequent retirement of the respondent husband, comma, it has been prayed that the alimony of rupees 20,000 per month granted earlier ought to be reduced, comma, commensurate with the current income of the husband. For sub next para, in support of the pleadings regarding pensionary income, comma, the respondent husband has annexed certain documents to the application for modification, which go on to indicate that the basic pension of the husband is to the tune of rupees 30,550 per month, comma, dearness relief is approximately to the tune of rupees 6,939, and the commuted amount adjusted per month is rupees 15,420. Full stop. Next para. On thus, comma, by giving due credit to the dearness relief and the other components of the income, comma, we find that the approximate monthly pensionary income of the respondent husband is to the tune of rupees 45,000, within bracket approximate, bracket closed. Full stop. While coming to the above finding, comma, we take into consideration the fact that the very factum of the of a part of the monthly income being commuted indicates that the respondent husband took a lump sum pensionary benefit at the time of his retirement, which has not been disclosed in the application. Full stop. Next para. In a rough estimate, comma, taking into consideration the expected standard and cost of living of a decent livelihood, comma, we are of the opinion that a balance has to be struck between the monthly income of the husband from pension and the requirements of the appellant wife. Full stop. Thus, comma, using the rule of thumb of 1/3 of the pensionary income, comma, we reduce the alimony of rupees 20,000 granted earlier to an amount of rupees 15,000 per month, comma, payable by the 10th of each current month by the respondent husband to the appellant wife. Full stop. The first of such current installments shall commence from the month of November 2025, and the respondent husband shall go on paying alimony at the rate of rupees 15,000 thereafter by the 10th of each succeeding current month. Full stop. Arrear of alimony, comma, if any, till October 2025 shall be cleared off by the respondent husband at the rate of rupees 20,000 as directed earlier. For some next para, can 5 of 2025 is disposed of accordingly. Full stop. Since the husband, comma, although sporadically, comma, has substantially paid the amount of alimony directed earlier, comma, there is no present necessity for attachment of the pensionary income of the husband. Push up. Accordingly, can 4 of 2025 stands disposed of as well. Push up. The appeal bearing FA 69 of 2023 be listed under the listed for hearing tomorrow. It will appear in the list day after tomorrow. It will appear in the list day after tomorrow, but it will be taken up in its turn.
Lordship. Now, my lord, since you all, the issue will essentially be with the permanent alimony, the disclosure of the entire retired benefit has to come up. Otherwise, my lord.
Before we take up the appeal, we cannot say that.
No, I'm just pointing it out. I leave it to your lordship because here, my lord, in this application also, your lordship has pointed it out that since he has not disclosed the why it is commuted and to what extent he has received, because his salary was, my lord, around 90,000 and odd. So he's retired. He served, my lord, for more than 40 years.
Yes, but is there any occasion for us to direct that unless
Because the
appeal is taken
financial
up?
stature of the husband, my lord, has to be ascertained.
Understood, Mr. Rai, but your challenge is against the divorce degree, the entire divorce.
Divorce decree,
Then we have to
and
record.
also on the, my lord, the permanent because, my lord, if your lordship goes to the judgment, my lord, there is a also, my lord, the evidence has come out that, my lord, that the marriage has irretrievably broken.
When the appeal is
Also,
near,
it is not a consent decree.
near about being taken up for hearing, at that point of time we
Not
direct, because the current at that point of time, what is his asset and income, everything has to be disclosed at that point of time.
As your lordship, as your lordship.
Let it be listed for the
Yes,
time
grateful.
being.
I understand. We're grateful.
Yes.
This is my
Haji versus Mr. Sen.
Yes.
It will take some time out.
No, Lord, I'll be very brief.
Yes.
There is an appeal hearing, Lord, your lordship will
appeal hearing?
Your lordship has directed, Lord, that the application and the appeal will be heard.
But what is the
My father executed a registered will. I am the daughter. So I objected to, Lord, the execution of that particular will. The beneficiaries are my brothers.
Your
beneficiaries are my brothers, two brothers. Now, Lord, in course of hearing of, Lord, the suit, Lord, I made a statement, I being the daughter, that I have no objection in grant of probate. Although, Lord, I had in the written statement objected to, Lord, about the execution and, Lord, the due attestation of the will concerned.
There are four of you, all of you.
No, Lord, I am only Uttara Sarkar.
There are four applicants. No.
Transferred to, Lord, the other persons.
Transferred your entire title. Then
yes.
Then I means your predecessor.
I means Lord Uttara here.
Uttara is still an appellant.
Yes.
And she has transferred. These are third parties to the family.
Third parties, they were added later on as opposite parties.
Very well. So you initially.
So I am confining myself not to the legal heirs. Lord, that's the reason. Lord, I have made my submission to that effect.
Probate was granted by the impugned decree.
Yes. Letters of administration.
Letters of administration.
Based upon an Order 12 Rule 6 application filed by my learned friend.
Because you had consented in it.
Because, Lord, there is a straight statement in my deposition about that. I said that no, the application may be allowed. But I'll give you, Lordship, Lord, the exact, Lord, what I have no objection if the petitioners of the case get decree according to the prayer.
Mr. Mukherjee, tell us these things. It was a contentious suit. You had initially filed. You had filed written objection.
Written objection.
And written statement. You stood by that. But in your deposition only, in one statement, it was.
I made that.
Let us see that statement.
Yes, that's. But your Lordship will kindly find a compilation that was handed over on the last occasion, but which starts with the will.
Yes. Yes, will is there.
Then, Lord, your Lordship got that. Lord, page 71.
Yes. We can first look at the examination chief. You were PW1?
I was, Lord, the OPW1.
Oh, OPW1, sorry. 54 to 71 then.
Lordship.
Where is it?
71. That is the statement at page 71.
So far as the compilation, there's some pages are
Oh, gondogol ache naki re? Huh? Ki gondogol ache?
70 page 69 PW2.
সেটা লিখবি তো রে বাবা।
Do you have OPW1 that admission at page 71?
Yes. Admission at page
71.
So that is for the time.
দাঁড়া সেবতী এটা কি আছে বলতো 50 থেকে 70 This is only 71. Bas, ঠিক আছে।
No, what is the previous page is also your deposition, no? PW.
PW, that is PW.
Very well. So PW1 is this much only. This is the total deposition.
Now well,
I understand Bengali and I answer questions reasonably. Quite unaware of the alleged will executed by my father since very well. No objection is there. How do you explain this, Mr. Mukherjee?
But because this was out of the context, because she did not understand what she was trying to say. I took out an application thereafter.
Within 24 hours?
May not be page 80, may not be within 24 hours. Maybe
immediately have to
but that was not quite in
you grew
3rd of April 2023. Our deposition date holo to 3rd of 22nd February 2023. Close proximity.
That's fine.
After order 1206 was.
Yes.
Then
because that was kindly see. I understand Bengali. I can answer any question reasonably which may be put to me. I'm quite unaware of
that is also a challenge.
Will.
You can take it as a challenge.
I am quite unaware of the alleged will, Exhibit 5, executed by my father, Devendranath Mondal, since deceased. If this be the statement, the following sentence which goes down in the deposition, I have no objection if the petitioner of this case get decree according to their prayer. This is not directly answering.
You have not applied for correction of the deposition.
No,
you had to do it in the same day before signing or after signing.
No.
But this page 80 is apparently an objection to their order 1206.
This was stated in English. This was translated in English. The LTI of my client is there. And she says that I understand Bengali.
Only put your LTI. The rest is with you. I mean, I'm illiterate. I do not know the contents.
I only put my LTI on my evidence in chief. I'm illiterate. I do not know the contents of the evidence in chief filed by him.
Poor lady. She does not know the contents of the evidence in chief. Then her evidence in chief also goes with some.
That is to a certain extent. Let us go by the fact that she is an illiterate lady. But let us give us some the credit to this person who is illiterate lady.
Absolutely.
Then going by the fact, let me just put it before your lordship that there is an objection, good, bad, indifferent. They do not put the will into this is a code of conscience. But the will has to be proved according to the conscience of the court and according to the law.
Will was otherwise execution was
otherwise execution was proper. I'll not be in a sense. The attempt at proof was by the PW1 and the attesting witness was there. In a sense.
The question here is whether court was justified in granting judgment on admission.
That is.
Then if you allow your appeal, you have to send it back.
For a contested hearing about whether my points of objection could be sustained or not. That is all that I mean to say.
And just let us see for the time being, let us see your statement challenging the will in the written
yes,
objection.
That is your lordship.
Or your written statement.
Page 12 to 70.
Yes,
page 12 to 70.
Everywhere. Sampadana registered, para 9 onwards.
Lordship. Then page 19, 14. About para 11. Well-being.
And in para 13, you also challenged because it was not, Devendranath Mondal was also illiterate.
No,
কথাগত কোথাও উল্লেখ করা নাই
তথাকথিত উইলের কোথাও উল্লেখ করা হয় নাই যে দেবেন্দ্রনাথ মণ্ডলের সম্মুখে উহা লিখিত পঠিত সম্পাদিত রেজিস্ট্রি হইয়াছিল এবং দেবেন্দ্রনাথ মণ্ডলকে তথাকথিত ওই উইল পাঠ করিয়া শোনানো হইয়াছিল এবং সাক্ষীগণ উইলের বিষয়বস্তু জানিয়া শুনিয়া দেবেন্দ্রনাথ মণ্ডলের সমক্ষে সই করিয়াছিলেন।
This is on the compliance
This
of
is on the blood, the compliance of
succession.
it.
But
So
it was
this,
challenged.
This was challenged, and therefore, my lord, all that I require is that to lead evidence on whether, my lord, I am correct or not.
Any judgment
Only on the basis of, my lord,
let
that
us see the input order before going to.
the learned judge, my lord, what it did on the hearing the application under Order 12, Rule 6, dwelt into, my lord, the merits of the matter. Not only confining, my lord, to the judgment on admission, but he dealt with, my lord, the evidentiary statement of PW1, PW2. Came to a conclusion that there is a valid execution of the will, without giving me an opportunity, my lord, to contest or to, my lord, give my, my lord, the arguments on, my lord, the evidences on record. Because the scope was only on the application that day. Today is fixed for passing order in respect of petition under Order 12, Rule 6.
Yes, internal page 4, second paragraph, he says that I find that it is a case of OP1, that there is no due execution attestation, moreover after demise such and such. And then he goes on to say that
it goes on, Lord, on the
I
merits.
further find that the petitioners through the evidence have been able to prove and all the
Yes.
merits of the.
So, Lord, what I was, Lord, deprived of was
hearing.
Lord, my hearing on, Lord, the
merits.
propriety of the evidences on record to say that what I wanted to convey in my
Argued
written
only on the
objection.
Order 12, Rule 6.
That is. If I succeed on the basis of what that is there on record. But not only on the basis of, my lord, the admission that was, my lord, the court allegedly, my lord, read into my evidence. Because that is not an evidence.
Translation. Yes, Mr. Shen, apparently we are against you, but satisfied.
So far as the
So you want to say, submit something?
No, Lord, your lordship knows about the judgment. Clear, ambiguous admission. There's no clear, ambiguous admission here.
Yes.
But so far as the page 71 is concerned, my lord,
Yes.
the evidence, my lord,
Yes.
my lord, will kindly consider the last line.
Right.
I do not know the contents of the evidence in chief filed by me.
What will be the effect of that?
But his entire evidence goes.
Then on merit it has to be decided. The suit has to be.
Merit-
Not on Order 12, Rule 6.
My lord, merit, my lord, the learned court has come to a finding, my lord.
Could not. While hearing Order 12, Rule 6. First line of the impugned order, see.
My lord, that is there, my lord. But fact remains, my lord, his evidence and he has not filed any
Did not
application for
consider.
recalling.
They did not get an opportunity to explain away.
But he has not filed any application for recalling of his evidence, my lord. So
Understood,
far,
but on
his
merits-
evidence is complete, my lord.
Neither the trial court nor can we,
Right.
while hearing an appeal from that, enter into anything, the merits of the your case, either of your cases,
But-
while hearing Order 12, Rule 6.
Right. But-
Only that.
But-
We'll
but-
direct it to be decided within a limited period, but send it back for
But,
retrial on
but
merits.
his evidence, my lord, has been closed, my lord, that remains there. My lord. She cannot be allowed to give further evidence, my lord.
We'll go neither way. We'll remand the matter from where, at the stage where it was when the Order 12, Rule 6 was filed.
His evidence was closed, my lord. We were.
We'll remand it at the stage when the Order 12, Rule 6 was filed.
My lord will clarify that.
No, we'll not clarify anything.
But so far as they will, if they make an attempt to, my lord.
They have the right to make an attempt.
But at this stage, my lord, after the.
Court has a right to reject.
But recalling of the evidence, my
Why
lord.
should we decide from here?
His
That would
both-
be premature.
But both the applications, my lord, application, he has filed an objection against my application, plus he has filed.
It's a shame in an adversarial system, particularly in a probate proceeding.
Right.
The endeavor of the court is always to strike at the truth, and it's a conscious jurisdiction. All these sermons, you know, we need not give it to you. All of you know, whoever does civil matters. So therefore, our endeavor is to reach the truth. Now, for that, one may need to file an application for recall. We are not permitting him to do that. Hard to do that. But nor are we precluding her from doing that. We are not saying anything. Rather, we are, in a sense, in your favor because we are relegating it back to the time of filing of the Order 12 Rule 6 application. Till that date, whatever evidence was there, from that stage, court will start. But after that, whether if they have a right to file a recall application, court has the right to reject it also. So therefore, we won't go into that at all. But we won't consider this, particularly keeping in view that she was an illiterate lady, Sir Sen.
Recalling provision was there, man.
It's still there.
But
once you remand the suit, it's still there.
But
they can also file a recall application in the appellate court. In the nature of, they are also order 18 rule 17, they can file it.
that is there.
We
but
cannot
till-
preclude order 18 rule 17.
Till the application was filed, they did not take any steps.
Now they can.
Neither, my lord, after the application.
Now they should, in fact. After your advice, they should. Order 18 rule 17 is there. Even afterwards, order 14 rule 27. So many provisions.
But so far as the, my lord,
So that will be after when they come before us. Order 14 rule 27. Now order 18 rule 17.
my lord will finally consider the order passed by the trial judge. He has
Enter it into the merits.
categorically.
That is the difficulty you face, Mr. Sen, apart from anything else. And apart from the obvious fact that this will treat to be a space sentence. The very first line is today is fixed for passing order in respect of petition under order 12 rule 6 and heard both sides at length, obviously, on that application. So he cannot go into the merits and decide on merits while hearing order 12 rule 6. He or she, we don't know whether.
My lord will only say that from the stage of order 12 rule 6, my lord.
Yes. Yes. From there it will be taken.
Evidence was found.
That will not say.
But
no, there are
Whatever stage was there at that point of time, it will. One line we say, Mr. Sen, that has an impact there. So we won't say anything. Whatever stage it was, court will know what stage it was. From the records, it will be evident what stage it was.
all petitions on behalf of the opposite one and two.
The present appeal has been preferred preferred against a judgment and decree whereby the learned trial judge, in a probate proceeding, while deciding an application filed by the respondents stroke defendants, under order 12 rule 6 of the Code of Civil Procedure, allowed the said application and dismissed and granted probate. Full stop. Next para, learned senior counsel appearing for the appellant submits that the appellant number 1, who adduced evidence as OPW1 in the probate suit.
letters of administration.
Oh, sorry. যেখানে probate বলেছেন and letters of administration. Thank you. In the letters of administration suit, who deposed as OPW1 in the letters of administration suit, allegedly admitted the existence of the will, which was the very premise of the application under order 12 rule 6 of the Code of Civil Procedure filed by the defendant stroke respondents. Next para, learned senior counsel appearing for the appellant's contents that the appellant number 1 stroke OPW1 is an illiterate lady and her evidence and the translation of the same in English has to be taken in proper perspective. It is contended that one stray sentence whereby it was recorded that she had no objection if the petitioners in the case get a decree according to their prayer, cannot be taken in isolation, whereas the entire tenor of the rest of her evidence and her specific written objection shows that the appellant number 1 contested the execution of the will and the validity of the same tooth and nail. Full stop. Next para. Learned senior counsel further argues that it is settled law that to come within the ambit of an admission under order 12 rule 6 of the Code of Civil Procedure, such double inverted admission has to be clear and unambiguous. Full stop. If there is scope of interpretation either way, the said statement cannot be construed as an admission. Full stop. Next para. Learned senior counsel appearing for the respondents submits that it is clear from the cross-examination of OPW1 that she categorically stated that she had no objection if the letters of administration was granted as per the petitioner's prayer, as per the prayer of the petitioner stroke plaintiff in the letters of administration proceeding. Full stop. That apart, comma, it is pointed out by learned senior counsel for the respondents that the OPW1 also stated in her cross-examination that she does not know the contents of the evidence in chief filed by her. For some next para, such statement itself vitiates the entire contents of the examination in chief, and there being no application for recall of the said witness, comma, it is argued that the premise of the objection to the letters of administration proceeding itself ought to go. For some next para, learned senior counsel appearing for the appellant contents in reply that the so-called admission was not clear and unambiguous, and it is reiterated that the same could have been explained away in hearing. However, comma, the learned trial judge, comma, while deciding the Order 12 Rule 6 application, comma, decided the main letters of administration proceeding on its merits without affording any opportunity to the present appellants to address the said proceeding on its merits. Next para. On a bare perusal of the impugned judgment and decree, comma, as comprised in order number 61 dated April 12, 2024, comma, we find that the order commences with the statement that it was a date fixed for passing order in respect of the petition under Order 12, Rule 6 of the Code of Civil Procedure, comma, thereby indicating that the entire scope of consideration before the learned testamentary court was an adjudication of the application under Order 12, Rule 6 of the Code. For sub next para, however, comma, while so deciding, comma, the learned testamentary judge entered into the merits of the matter and appreciated the evidence led by the parties at length. Full stop. The learned testamentary judge, comma, inter alia, comma, found that the petitioners within bracket present respondents bracket close, comma, through the evidence of PW1 and PW2, comma, had been able to prove that the Exhibit 5 will was executed on December 11, 2001 and registered on December 12, 2001, and it was actually executed by the testator duly. Full stop. It was further found that the testator was physically fit and mentally alert at the time of execution. Full stop. The following findings in the impugned judgment also go on to show that the learned judge adjudicated the main suit on merits without giving any opportunity to the appellants to address the suit on its merits. Full stop. In fact, comma, the very opening sentence of the impugned judgment shows that the consideration of the court was confined only to the application under Order 12, Rule 6 of the Code of Civil Procedure and to the alleged admission, comma, if any, on the part of the present appellant number 1 in her evidence. Full stop. Next para. Thus, comma, the learned trial judge evidently traversed beyond the scope of the adjudication before the said court and decided the main suit on merits while deciding only the application under Order 12, Rule 6 of the Code. Full stop. Next para. Apart from such patent jurisdictional error, comma, we find from a careful and comprehensive, comma, meaningful perusal of the of the alleged admission of the appellant number 1 as OPW1, comma, that the said sentence was only a stray statement. Full stop. The statement is as follows, colon diye, double inverted moddhe, I have no objection if the petitioners of this case get decree according to their prayer, double inverted close, full stop. Next para. Apart from the fact that the OPW1 is an illiterate lady, comma, it also has to be taken note of that sometimes the purport of a statement is lost in translation. Full stop. Next para. Moreover, comma, the said statement, comma, which is sought to be portrayed as an admission, comma, goes against the tenor and the grain, GRAIN, of the rest of the evidence of the OPW 1 stroke appellant number 1, as well as her categorical denial of the execution of the will and the validity of the same in her written objection. Push up next para. Hence, comma, this court is of the opinion that the stray sentence in question of the OPW 1 in her cross-examination could not be construed to be a clear and unambiguous admission of the plaintiff case in the latest of administration proceeding on the part of the OPW 1 stroke appellant number 1, and as such, comma, the learned trial judge erred in law on such count as well. Full stop. Next para. In view of the above, comma, FA FMA.
Number কত করেছে?
FA.
111 of 2023 FA.
Thank you.
Thank
FA
you.
number 111 of 2023
Lordship.
of 2023 is allowed on contest, comma, thereby setting aside the impugned judgment and deemed decree being order number 61 dated April 12, 2023, passed by the learned additional district judge, second court at Bongaon, district North 24 Parganas in OS 06 of 2019, and remanding the matter to the testamentary court for a fresh adjudication on merits of the case. Full stop. The learned testamentary judge shall now proceed from the stage which the suit had reached at the time of filing of the application under Order 12, Rule 6 of the Code of Civil Procedure by the present respondents, and, comma, upon granting adequate opportunity to the parties, comma, decide the suit in accordance with law, independently without being unduly influenced on merits by any of the observations made above. Full stop. Next para. It is expected that since the suit has been pending for quite some time, comma, the learned trial judge shall make endeavor to decide the same as decide and dispose of the same as expeditiously as possible, comma, preferably within 6 months from the date of communication of this order to the learned trial judge. Full stop. Can 1 of 2023 is disposed of consequentially. No order as to cost. Interim order, if any, stands vacated.
Grateful. Lower court recorders still.
Did not come. That stage did not arrive, in fact.
No, I think we were directed to file, my lord, this Lord, the informal, my lord, the compilation of documents. That was the direction.
Yes, yes, with the papers.
Lordship. Grateful. Thank you.
Item number 18.
Appear for the appellant, Your Lordship. I mean, led by Mr. Surya Prasad Chattopadhyay.
The appellant's name suggests that your non-appearance on the last occasion was justified. The name of the appellant. Your name is Durlabh. So,
Yes.
Madam, appearing for the respond number 1, 2, and 3.
very good. What is the application about?
This is a section 5. However, Your Lordship, service as per the track reports has not been totally completed.
You have for respond numbers?
1, 2, 3, and 5.
And 5. What about 4? Appear for 4 also.
No,
You can decide the application.
Case of art till today.
What happened regarding 4? What is the endorsement? Track report? What is the track? In any event, he is Durlabh Rai. You have got him and you are missing the opportunity. Not served.
Your
Then tell
Lordship,
us the
what has
endorsement.
happened is most of the track reports downloaded from the website has come inconclusive. It has got stuck halfway, and I have already
Halfway means?
like delivery status is not being shown. Like one in 2 of
That's
the
the glitch in the postal
Yes,
system.
Your
Yes,
Lordship.
many
Many
people
I'm
have
not
to
being able to ascertain if learned sir has appeared for most of the respondents.
Did these respondents, all the respondents appear together in the trial court? Let
Yes,
us
a
see that.
written statement, joint written statement was filed
By all.
trial court.
Then we'll deem it to be good service on all.
There's a section 5 application.
Achha, what is the delay?
110 days.
You filed your affidavit of
Yes.
service. 110.
110 days.
Explanation?
Yes.
Financial constraints being the main ground.
Para 8, my lord. The cause of delay has been explained.
110 days after exclusion of time taken in obtaining of certified copy.
You're in grocery business.
Yes. Grocery shop, small grocery shop in a village.
Grocery, you have said business in your. Anyway, what else could you
it's
say?
a shop.
Yes, what do you say? Section 5.
I have nothing to say, but that is up to your lordship whether I will consider.
Affidavit of service filed today is be kept on record. Full stop. Learned counsel appearing for the respondent numbers 1, 2, 3, and 5 submits that he has no instruction to appear for the respondent number 4. So, although from the affidavit of service it is not clear as to whether all the respondents have been served properly, since all the respondents contested the suit together in the trial court, it is deemed that good service on respondent numbers 1, 2, 3, and 4, 3 and 5, who are represented in court today, comprises substantial service on respondent number 4 as well. Accordingly, the application for condonation of delay is taken up for hearing. Next para. We find from the explanation given in Can 1 of 2023 regarding the indigent financial condition of the appellant that sufficient cause for the delay has been made out. Accordingly, upon hearing both sides, Can 1 of 2023 is allowed on contest without any orders to cost, thereby condoning the delay in preferring FAT 320 of 2023. The appeal is hereby deemed to stand registered and admitted. What is the appeal against?
It's filed a suit for defamation, seeking monetary
Dismissed.
compensation.
So there is no scope of stay.
No, there is.
So we'll pass the usual directives for paper book and all. You'll
Great.
in view of appearance of the respondent numbers 1, 2, 3, and 5 through counsel, service on the said respondents, service of notice of appeal on the said respondents is dispensed with. The appellant shall put in postal requisites and dues, postal costs and due requisites for service of notice of the appeal on the respondent number 4. Next para. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm for the appellant.
You are for the
Appellant.
That's
Lordship, last occasion, Lordship, we
it
filed.
has not been called on you. Yes. Yes.
Lordship, I'm for the appellant, Lordship. On the last occasion, Lordship, we filed a section 5, but the service is not complete, Lordship.
Not yet complete.
Kindly adjourn for 1 week, Lordship.
On the prayer of the appellant, in view of service having not yet been completed, let the matter stand adjourned till November 10, 2025.
Grateful, Lordship.
Number 20.
We face a very weird problem in this matter.
Yeah, problem in this matter.
Very weird. But what happens is in a matrimonial suit, the wife, my lord, has contracted a second marriage and she lives happily, my lord, somewhere in Rajasthan. Now the suit is dismissed, my lord, on the ground, my lord, of jurisdiction. Now, of jurisdiction.
Your suit for divorce?
Yes, my lord.
You say she has married a second time?
Yes, my lord. And she admits that she sent a written statement, my lord, to us by, my lord, by post, saying that I have got no objection if you get a degree
did not
for
file it
divorce. But did not file it in court. Now what I, my lord, suggested on the last occasion is to, my lord, go to the place where she resides. We went to the place where she resides. We found her there with the husband. But she refused to, my lord, take, my lord, the service. So what I was praying is, appoints a special officer
to what?
To go and at least, my lord, take that and show it, tell your lordship.
Your advocate and record to do that.
I have no. Chalo jao. Rajasthan ঘুরে আসবে. Huh?
Same result as the.
না তুমি সেটা রিপোর্ট দেবে, তুমি স্পেশাল অফিসার হিসেবে যাও, তা নাহলে আর তো কোনো উপায় নেই, তা নাহলে আবার করে দৌড়তে হবে.
Did you know you took this much upon yourself when you took the brief?
Wait, Mr. Lakhotia is from Rajasthan. He can also go. He's in my chamber. He is
him.
Yes,
You're from Rajasthan.
He's from Rajasthan.
So at the expense of your client, you have a visit of your home, and
So,
but no, advocate should not be appointed. But
I have
no,
no other
what is the difficulty? I mean,
difficulty is below the
in
court
the
says that-
appeal, you have served the copy of the application on
yes,
them.
below. Yes, no, but
No,
she
we
has
have
not received it because we didn't know the exact place where she was. So there is an order, if your lordship sees on the last occasion, that we should be going to the paragraph number 5.
Oh, actually, by personal mode.
My lord. My lord's only.
So you failed in that also.
I went there, found her, but she refused to acknowledge it because it's done, my lord, by the client. So there might be some sort of, my lord,
When you sent previously by post, what happened? What was the
did not refused.
Refused.
No, no, it wasn't recorded, but refused.
No, no,
No,
That was not served.
could not have been served, my lord, on her.
No, but you have to send by post. Why?
We sent it by post. It came back, my lord, not unclaimed. But now, of
Let
course,
us see the affidavit of service.
unclaimed is good
Unclaimed,
service.
you will take to be good service
Good
and
service.
proceed with the matter.
Look, I had a different problem. Why I wanted this was there might be a problem with respect to, my lord, jurisdiction as well.
Yes.
In the sense, my lord, that the marriage, my lord, happened, my lord, somewhere they lived together in, my lord, lastly
In Kolkata.
in Kolkata. But this is suit was filed, my lord, in Barashat. That is where I said, my lord, if they had come, because territorial jurisdiction, your lordship knows, my lord, can be waived.
Mr. Chatterjee will dismiss your appeal.
That
What
delays
has
the
been done?
entire
Dismissed on the ground of jurisdiction. We'll say this will not preclude you from filing a.
Order 7 Rule 10 will apply, my lord. Your lordship may always send it, my lord, to the
Then
this
we
suit
have to
itself.
modify it.
That's exactly why.
Modification cannot be done without. We'll say this will not preclude you from filing a suit on the self-some cause of
that
action
will
before the.
create another, but entire proceeding will start again afresh.
So what?
Now the problem is again service. I'm not even getting into, my lord,
I
the
live in a
merits.
Rajasthan court where the she is
There also, my lord, she will not appear.
Mr. He will be
No,
contacted.
Millard, what I wanted was if somebody can go and ask and tell your lordship whether the written statement that she's filed, whether that is true. Or
Chatterjee,
not.
I mean that would be difficult. Your appeal will be lingering unnecessarily.
Millard, I'm ready to
Dismiss the appeal and give you liberty to
Millard,
appeal the
if I go back in the suit for the next 3 years, I will not be able to get anything, Millard, from this court.
Suit has to be filed either
Millard,
way.
that's why
Even if you return the plaintiff, it to be presented before the appropriate.
Yes, if it's Order 7 Rule 10, even then, Millard,
What
then
was the
for
stage of the
presence.
suit?
Written statement, Millard, filed or verbally rather.
They're not filed then.
Not filed. So
it has
the
to start
entire
from the
thing,
inception.
Millard,
What is the difficulty if we affirm this and give you liberty to appeal?
I say, Millard, my respectful submission and Lordship's kind consideration. I will try and, Millard, from here itself, if she comes and gives consent to your Lordship, even
She's
by
not
a
doing
written.
that. She's not doing that.
She's done it.
You went there personally. She's
No,
not doing that.
She's done it. Millard, if your Lordship
Even-
sees,
even-
just
see.
the authenticity I need to prove to your Lordship, nothing more than that.
Need not. Mr.
Kindly have a look at the
Chatterjee,
written statement.
jurisdictional point, we'll say that we are satisfied that this court did not have jurisdiction.
Then kindly sends it, Millard, under Order 7 Rule 10, could not have dismissed it. If the court did not have jurisdiction, kindly sends it to the Alipur court.
Then Mr. Chatterjee, you would have more options, either in the Rajasthan court, appropriate Rajasthan court,
Millard, Rajasthan court,
where she resides. You can file there. That option will be open to you.
Millard, even this option, I'm saying, Millard, I'm kindly allow me to exercise this option of, Millard, Order 7 Rule 10.
It has been recorded by the court anywhere in the impugned judgment that you last resided at Alipur.
Millard, that's the
show us that.
Kindly have a look at the written the impugned order. They got married, Millard, in Calcutta.
Oh.
In Bhawanipur.
So that is also one of the forums.
Yes, that's why I wanted to.
Where is that?
Page 84.
No, it's from the judgment itself.
Yes, 84.
Which can?
In the
Give the internal page.
Internal page.
There are no paginations in it.
No, internal page memo ta kothay?
Decision with reasons.
Yes, the first line.
Yes,
the first paragraph.
Has claimed.
Was registered. was registered before the Hindu marriage register.
Petitioner has claimed.
Area, but it's a marriage register. I can always prove that.
Therefore, it seems that the marriage was solemnly registered outside the
Outside jurisdiction. They last resided, my lord, in Bangalore.
The cost title of the print has been resetting also.
The judgment itself, my lord, if I can say, my lord, is wrong, because if it's on jurisdiction, my lord, Order 7 Rule 10 ought to have been, my lord, exercised. And your lordship knows, my lord, section 21, if it comes into play, then this is an objection with respect to territorial jurisdiction, which can be waived under, my lord, section 21. And she's waived that, because if your lordship sees the written statement, my lord, we've annexed it.
Written statement, she has
Not filed.
So we cannot
She
look
sent
into
it
that.
to the court as well. It's on record. She sent it to court as well.
In the impugned judgment.
No, not in, because the court did not consider it, my lord. She sent it to the court as well, saying that I have got no objection. Looks to my plight as well, and have a little bit of
You
sympathy.
exhibit those documents, will dispose of the appeal right now.
Very well.
Order 7 return করে আলিপুরে পাঠিয়ে তো মডিফাই করে কিন্তু আদার সাইডকে না শুনে সেটা ঠিক হবে কি না শুনে ঠিক হবে
Other side
তো আমি যদি ডিসমিস করতাম তো এটাই রেখে দিয়ে ওকে লিবার্টি দিতাম যে সুট ফাইল করতে পারে যেখানে খুশি you can file the suit in Alipur. You lose these documents
completely. Again, again, I'll have
documents you can exhibit there.
Exactly, and that will take me 3 years. And my marriage, my lord, is.
Then if you return the plane, it will take you 3 years.
No, my lord, if it, subject, I'm never say no, because it will start from here. Because these documents
Here
are all
is what is here. There is no written statement as yet on record.
Filed before the court. She sent it, my lord, by post. It's on record. It's on record. So what happens here, my lord, that if it's on record, then I can show, my lord, from that itself that look here, she said that there is no problem. But I would say, my lord, the easiest way would be to send somebody so that your lordship can take it on record here and, my lord, give relief. She's happily married. She has a child. She even came out of the, my lord, somewhere in Bikaner, no? Jodhpur.
So what should we do?
My lord, my respectful submission, my lord, if your lordship, my lord, gives me abhay, is that kindly send somebody so that some evidence is before your lordship that she says that if the divorce is granted,
Stay
there is no
personal
problem.
mode you attempted, she refused.
That's my saying. Lordship sends an officer of court, which make it more authentic.
No, you are directed to serve copies
I did
personally.
So. I went so.
So you have to file an affidavit of service saying what happened there. You must have stated there that she refused.
Yes, yes.
Let us see that.
Have a look at the first page itself.
Family member means you have not given clearly what is your.
No. But behind such and such under cover letter, there is a respondent refused respondent.
You have not given the name of your. Yes,
the
your father
respondent.
is Deepchand Banti. Besides such and such.
And even the original plot was sent.
No.
No,
They
I
refused to
wanted to say, refuse to receive. What I wanted to say, my lord, this is there. Refusal is good service. Your lordship may, my lord, in any way, my lord, take note of that.
But that can only dispose of the application.
Dispose of the application.
Application is for what? Can one?
My lord, that is only for, my lord, get the matter here heard.
Yes, but it is for stay.
Stay. So stay cannot be granted.
No.
There is no.
But then we'll have to direct the usual, pass the usual directions.
That's why I say, my lord, to obviate that and to keep, my lord, to expedite.
Regarding the notice of appeal, we cannot direct personal service. That would be too risky.
Then
we don't know. We are hearing you only. We are not hearing.
I bow down. For that, my lord, directs me to serve on this address. The address which is given, my lord, in the affidavit of service here. Or both, whichever.
No, present address you have given. That is in the cost title itself.
Yes. That's in the cost title.
So serve at the address is given in the cost title. No difficult. 3 addresses are given in the cost title. 3 or 4.
Yes.
Serve at,
yes. Very well.
You will put in postal service on all.
That will take a little bit of time. So it gives me 2-3 weeks, my lord.
No, not what 2-3 weeks. You put in the requisites and it will go to court.
Requisite today.
Yes.
Through court, pilot kindly directs the office to do it, pilot, within 3 weeks. And he's ready, but they are marriageable age.
What is the age?
It's about pilot 30 something. Age of
There is no age called a
30,
manageable age.
34
Every age is manageable.
34 years. I wish, my lord. But
No, not your wish.
What's-
It's happening internationally, nationally.
nationally,
You're
locally.
you are a prehistoric creature now. 34 is quite manageable.
34
So,
is very manageable. And
but what can we do? We cannot. We could
only
have,
direct
we were
statement.
trying to help you only, but yes, you lose that written statement.
Entirely.
But you can always exhibit, have that
My
exhibit.
lord,
in a
I
different
bow
suit
down,
also.
but again, that exhibit I will bow down. Again, the process of sending notices will start again.
Notice will start in any event.
Yes, my lord. So this now, my lord, if I can refusal, if it comes, it's good service, and I can show you a lot.
We gave you the option. You affidavit of service filed today be kept on
I
record.
gave it to them much earlier. But
Affidavit of service filed today be kept on record. Full stop, it transpired that despite attempt to serve, the respondent is deliberately avoiding service. Full stop. Accordingly, we take up the application for hearing. Full stop. Since the appeal has been preferred against the ex parte dismissal of a divorce suit on the ground of jurisdiction, comma, there is no scope of grant of stay. Full stop. Accordingly, we dispose of Can 1 of 2025 by directing the appellant to put in postal costs and requisites for service of notice of the appeal on the appellant within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of informal paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal as and when the same is ready for hearing.
right. So grateful to much.
Yes.
21, I beg to appear on behalf of the appellant, but my lord, service is not yet completed. I am praying for an.
When did you send?
I have sent after reopening. Actually, the clerk, my lord, was pleased to pass the order on 8.
Learned counsel for the how long should you give?
1 week, my lord.
Learned counsel for the appellant submits that service is not yet complete. Full stop. Accordingly, on the prayer of the appellant, comma, let the matter stand adjourned till November 10, 2025. Next.
Number 22.
Lordship, I am appearing on behalf of the respondent.
Yes.
Lordship, I am praying for a short accommodation.
Why short account?
We just received the brief from the client.
Actually, regarding this Talabana and postal cost, you have not yet put up written up notice form. That is the office report. Please comply with that. Rupees 4 Talabana and
Yes, my lord.
rupees 4. It will be difficult for you to get rupees 4.
Yes.
Give rupees 5.
Yes, my lord.
An adjournment is sought on behalf of the respondent. We'll give you 1 day's accommodation.
Lordship, I kindly leave to file the Wakalatnama.
Achha, very good. An adjournment is sought on behalf of the respondent, full stop, on the prayer of the respondent, comma, leave is granted to the learned advocate appearing for the having instruction to appear for the respondent to file Vakalatnama during the course of this week. Full stop. Next para. The appellant shall, comma, in the meantime, comma, put in Tolabana, postal cost and written up notice forms in terms of the office report dated October 28, 2025. Full stop. Next para. Let the matter be listed next on November 10, 2025.
I'm good.
Thank you. Correct হয়ে যাবে।
Number 23.
May please, your lord.
Yes, please.
Pursuant to my lord's order, my lord.
You have served good
Yes,
service.
Yes, my lord.
And they have received.
Yes, my lord.
Yes. This is against divorce decree or what? Oh no, both.
Lordship already passed to order, my lord, earlier on 15th September.
Achha.
Second page, my lord. Point number 6.
Till disposal of the application, now we'll dispose of the application itself and put director to put in the request.
And my lord, I deposited the postal cost, my lord, and my lord, Tolabana for
Oh, trial court records also, special messenger also you must have deposited.
already deposited, submitted.
Also, then we'll just dispose of the injunction, the application
Lordship.
and give you liberty to mention the appeal.
Lordship. After receiving the paperwork, lower court.
After it's made ready, the other directions are already there.
Yes, yeah.
Paperwork directions are there. Affidavit of service filed to be kept on record. Full stop. Despite service, none appears for the respondent. Full stop. Since the appeal has been preferred against a divorce decree and we are prima facie satisfied that an arguable case has been made out, comma, can 2 of 2025 is allowed, comma, thereby restraining the respondent from contracting any remarriage during pendency of the appeal. Full stop. Since directions for early hearing of the appeal have already been given, comma, no further direction need be given in that on that count. Full stop. Liberty is given to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Obliged.
Thank you.
Next matter, we'll pray for short passover, my lord.
We are granting you passover for 45
No,
minutes.
my lord, the first matter before Justice Bosak division bench. That's why, my lord, both of us, Mr.
Then in that case, Lord, takes it up, Lord, day after tomorrow.
Definitely not. Justice Bosak's matter will be over in 5 minutes. We'll grant you a short
Yes,
passover.
my lord, we shall come back.
No, no relief.
Very well.
Grateful.
24, my lord, I am for the respondent led by Mr. Tonmoy Mukherjee.
You are paying for time. Pass over.
I'm for the appellant, my lord, petition matter is first time appearing, my lord.
What is the application for, Mr. Chakraborty?
Application for injunction, my lord, I was having injunction before the court below, but due to the dismissal of the suit on the ground that I have not paid for relief for recovery of possession under section 34 of the specific relief act, the suit has been dismissed. Well, my case is that defendant number one's father was the tenant, and defendant number one's father died, and defendant number one is trying to sublet. Well, trying to sublet is not a mischief for eviction, my lord. For that ground, section 34, my lord, I cannot ask for I cannot ask for recovery of possession on the ground of somebody is attempting to sublet unless the mischief is completed. So, my lord,
You entered into that agreement for purchase with the owner.
No. My lord, I am the Chika tenant.
Specific performance of what?
No, specific relief act.
Suit was for what?
Suit was for, my lord, only for the injunction and declaration that defendant number one has no right to transfer sublet. And defendant number two is the a person who is trying to trespass.
You are the owner.
I am the Thika tenant. I am the Thika tenant.
And he is your bharatia. One is your bharatia.
One's father was the bharatia, father died, and one was trying to transfer.
So you don't want an eviction. You simply want an injunction.
Yes, only.
Very well. Now, what sort of injunction you are asking for? Same.
Not to transfer, assign, and part with possession.
The present appeal arises out of the dismissal of the suit filed by the appellant for injunction restraining the defendant stroke respondent number one from transferring, alienating, and or subletting the subject property in favor of the respondent number two. For next para, the appellant's claim to be the Thika tenants in respect of the suit property, and the respondent number one is claimed to be a bharatia under the appellants.
Respondent number one's father was the
the father of the respondent number one is claimed to be the bharatia under the appellants. The learned trial judge dismissed the suit primarily on the ground that the suit was barred by section 34 of the specific relief act in view of no recovery of possession having been sought. It is arguable whether such stance of the learned trial judge was correct in law in view of the nature of relief sought in the suit by the appellants. Accordingly, a prima facie case for hearing the appeal on merits has been made out. The respondents and or their main and agents shall remain restrained by an order of injunction from transferring, alienating, encumbering, transferring, alienating, and or encumbering the suit property in any manner in favor of third parties till disposal of Can 1 of 2025. The appellant shall serve copies of the application on the respondents, indicating that the application shall be listed in the monthly list of December 2025. The appellants shall file an affidavit of service at the next hearing. Should we direct you to put in the special messenger costs also? Yes. The appellant shall also put in postal costs and requisites for service of notice of the appeal on the respondents. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the application and the appeal respectively for inclusion in the list as and when the same is ready for hearing. Thank you. 26 থেকে টানা
26 to 45
26 to 45 একসঙ্গে দেখে দিন
my lord
when the appeal is ready for hearing, liberty to mention the appeal as and when the same is ready for hearing. Application to the thank you. Yes.
Well, 26 to 45, section 5 allowed 10,000 cost to 4 lakhs. I have already paid 4 lakhs. Yes. Now, my lords, kindly grant a stay
and my lord, paper book may be prepared by us, and vessel management cost is to be
Same
paid
is
by
you have
us.
to deposit the awarded amount.
And my lord, kindly, this coordinate by, my lord.
No, but we have refused on
Speaking
some.
by your lordship, my lord.
Earlier refused. No, my lord, there is a case, there is a point.
Listen, Mr. Mukherjee, the difficulty is because you are land losers, we can appreciate, but there will be
4 lakhs we have already made.
We may permit you then subject to security.
Yes, your lordship has passed an order. I have got it.
Mr. Sengupta, if they furnish security to the satisfaction of the
Yes,
register, we
bond
can
and
permit that
security.
50%.
Wow.
No difficulty on that.
Security means money, at least money they have to
No,
pay.
not money, bank guarantee, maybe bank guarantee or whatever to the satisfaction.
Bond,
But if they fail to,
public security.
but if they
That
fail
is the reason the security is directed.
yes, then my lord 25%. Because my lord, kindly see 30 because the district collectors there is compensation award money that is 66,000 per kata. And not each 26,662,
Whatever
and
is
it
the
was
enhanced
enhanced to 66,000.
Whatever is the enhanced amount, 50% of that they
No, not 50. I'm
50,
requesting.
20, all the same.
50%. Kindly in earlier cases, my lord, all those cases. my
50%
lord-
you have directed.
No.
I have got.
We have got 50, 20.
My lord, in that when my lord was my lords were sitting in courtroom number 10. Courtroom number 10, my lord has refused to give that. My lord, in so many cases, I appeared. My lord, kindly do not make
All these
50%.
applications arise out of the same
Same.
application. All these applications are taken up together for hearing since the appeals arise out of the same acquisition process. For sub next para, the present appeals have been preferred against enhancement of compensation payable to the land losers. For sub next para, since arguable questions of law and fact are involved, the appeals are required to be heard on merits. Full stop. Accordingly, a prima facie case has been made out. Full stop. Next para. In such view of the matter, can do in all the matters.
Can do, yes. That is application for stay.
Stage
All.
can do in all the
Can
can 2 of 2025
because can 1 has already been
in all the appeals are accordingly allowed on contest, thereby granting stay of operation of the awards impugned in the respective appeals till disposal of the appeal. Full stop. Next para. Such stay is subject. Such stay shall continue in an unqualified manner for a period of 1 month. We are giving you.
my lord, not 1 month, because my lord, the decretal amount, my lord knows that it has to be
How much
approved
time?
by
Tell
that
us.
45 days. At
Very
least.
well.
My lord has previously passed
Very
this type of.
We'll give you till the end of December.
Yes.
Unconditionally till December 24th, 2025. Full stop. Next para. In the event the decretal amounts are deposited by the appellant with the registrar in each of the cases within such period, such stay will continue till the disposal of the appeals. Full stop. In default, however, the stay shall stand automatically vacated. Full stop. As and when such deposits are made, the Registrar General shall invest such amounts in short-term interest-bearing accounts with any nationalized bank, banks, and such amount shall be subject to the outcome of the appeal. Full stop. Shall deposit যেখানে বললাম shall deposit 50% of such amounts. তারপর যেটা বললাম full stop. Next para. The appellants, the respondents in each of the appeals shall be entitled to withdraw 50%, the balance 50% of the deposited amounts subject to furnishing security to the satisfaction of the Registrar General. For sub next para, such withdrawals as well as the deposited amounts shall be subject to the outcome of the appeals. Full stop. It is made clear that such withdrawal and deposit shall be without prejudice to the rights and contentions of the parties in the appeal. The appellant shall put in. In view, you are appealing for all the respondents in all the matters. In view of the appearance of the respondent in all the matters,
we will put the special message
service of notice of appeal on all the on the respondent in all the matters is dispensed with. Of the appellant, the trial court record shall be brought by special messenger at the cost of the appellant in each of the matters to be deposited within 4 weeks from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the service of notice of arrival of the trial court records in each of the matters.
Special messenger is to be paid by Monday, my lord. Next.
Full stop. The special messenger costs for bringing such. No, we gave you 4 weeks time.
My lord, special messenger cost, I think 21 matters, well, because the government money, 20 matters.
Special messenger the 4 weeks dilam na?
4 weeks.
Oh, 4 weeks.
4 weeks, not 4 days.
No, sorry,
You want
sorry.
it by Monday.
So they will make it Monday.
No.
I'm doing
As a liberty to the parties to mention the appeals for inclusion in the list as and when the same is ready for him.
In default,
Are ready for him.
in default of them,
So the
Yes,
বলেছে,
yes,
sir, বলেছে।
the respondent may be given liberty.
Oh, when they default, then
The default হবে না এখানে।
if they default in that, you mention.
My lord, 50%, my
You
lord,
deposit the entire amount.
I will deposit the entire amount and the
50% will be
50%
invested.
subject to the approval of
Everything, all the matter, all the deposits and withdrawals will be subject to outcome you have said.
that the registrar general. He will decide whether, if they satisfy that, kindly clarify, otherwise they will.
Security
You have clarified, but instead of he, you have said she.
Oh, sorry.
Security oblique bond. On the last matter, security bond oblique.
No, oblique motive should be attributed to the
Yes. Oh, Baba,
Because
bond.
they are all cultivators. It is not.
Cultivate. You have got the money, sir.
Oh my God.
Enhanced money you have got already.
That's a call on the next matter.
The obligation.
46.
95 का एक्शन बोले थे
95 কে আছে?
95
46.
95 কে আছে আমাদের?
95
একই same.
হ্যাঁ same
Well, I think 95 is also same. They
95.
তাহলে একসাথেই হয়ে যাবে।
yes
95 is something else. Intra-court appeal.
ও তো হ্যাঁ ওটা নয়
পশ্চিম আচ্ছা
এই তো নাম রয়েছে তোমার
ঠিক আছে
হ্যাঁ
ওই জন্য
46 who is appearing.
এটা এই যে তোমাদের নাম
None appears for the parties at the time of call.
পশ্চিম বর্ধমান
The matter is adjourned for the day. Mr. Kormakar is there, Mr. Mukherjee? তাহলে এরপর 5 ওভার ম্যাটারটা ডেকে নিন।
For the respondent.
On the last occasion, my lord was pleased, my lord, not to extend the interim order initially granted by my lord.
আচ্ছা
But
Why?
today, for the final hearing of the application. The issue before my lord is, my lord, the plaintiff is the appellant before your lordship.
Right.
Your suit is for, my lord, declaration that a particular settlement deed in the garb of settlement deed is void, and, my lord, for enforcing some share in the joint property. This
Enforcing
is, my lord,
means? Enforcing shares?
my share is being denied by the, my lord, defendants
Yes.
in the garb of a settlement deed.
Right.
Say, my lord, that the settlement deed is void ab initio does
All
not
right.
apply to me. Lord, trial court, learned trial court, my lord, dismisses my, my lord, suit on 2 grounds, principally on 2 grounds. The first ground is on the ground of limitation, saying that I had knowledge of this settlement deed in the year 2004 when a criminal proceeding was lodged by, my lord, the respondents. And that's why the limitation would have expired in 2007. So, my lord, I am barred by law, barred by limitation. The other aspect is, my lord, the trial court came to a finding that the settlement deed is legal. These are the 2 challenges before your lordship in my appeal. Lord, I say that the settlement deed in the name of settlement, not fresh rights could not have been created. It had to be only created by virtue of a sale, my lord, or gift, or a like consideration, bearing like consideration.
This was not a registered deed.
It's a registered deed. It's a registered deed.
Then whatever may be the nomenclature, if transfer is made,
Consideration,
transfer is made.
among consideration. Family arrangement registered. But, my lord, if there is no pre-existing dispute for which the parties wanted to settle the dispute, lord,
Whatever may be the nomenclature, Mr. Kormakar, if title is transferred or settled, either it's a deed of exchange or whatever, it may be a deed of transfer.
exactly, my lord.
That cannot render it void.
Lord, registration, I could have understood it's a partition.
Why should it be void for that?
Not void because of lack of consideration. There is no consideration.
Who are you?
Lord, I am the daughter of, my lord, the person who had executed.
The person who executed did not
My
challenge
mother.
it.
My mother had.
She did not challenge it during her. She's still alive.
No, she's dead.
So she was alive. She did not challenge it. What is your locus? You step into her shoes.
Look, that's exactly what I am on. Look, then a deed which has been executed, if it is void, it did not create any title.
Void? Why?
An issue.
Because it was not either in the form of a sale deed or a gift deed or something like that.
Some kind of consideration had to pass. Any deed had to have a consideration. For gift, my lord, the consideration has to be natural love and affection. For sale,
No. If I want, I may gift it to anybody without any consideration. For gift, no consideration is necessary.
No, for give the consideration is my lord, the natural love and affection.
That we write in the gift deed.
Yes.
It need not have any consideration.
Not the natural love and affection. That is
Unnatural love and affection can also lead to a gift deed.
But
some people may have an unnatural love and affection.
But here is
so they also can gift.
But here is a case.
Write it, it's a habit.
But here is a case where absolutely everything is absent. There is no consideration at all. The reason is because I was married away, not with in a proper house. That's why not my right is being curtailed.
The owner of the property can do that, Mr. Kormokar. Can deprive her daughter.
Yes, can deprive her daughter.
Has done it.
It has to have some basis.
Why should it be void for that consideration? Who are you to say? You are deprived. You cannot say that she did not receive consideration after her death. That too.
But if the deed does not bear a consideration, Lord, by reciprocal submission, Lord, even if the non-executant of that deed, Lord, can also take that.
The peculiar propositions of law, you're non-executant of the deed, busybody. You are a busybody. You are nobody to the deed.
But I'm claiming the right. I'm claiming the right
what
from
right?
my
Her property she gave to somebody else. You are not a party to the deed. You cannot challenge it and say that no consideration passed. That only the transferor could say.
So that is exactly what the challenge is about. Look,
then that is exactly the ground on which you will dismiss.
One is lack of consideration. The other is the deed was otherwise not properly executed. Those were.
Why? There were spelling mistakes, or they did not look good, or the paper quality was bad.
No,
Mr. Kormokar, bad. We are hearing it so long because Mr. Mukherjee has been engaged. If it was someone more junior, we would not have listened to you for 10 minutes even. Nothing in the matter. Rightly done. Very good judgment. We need not look into the judgment also. You have got no right, that has been held. Yes. Let us go backwards. Limitation also, right? Limitation also, you have got nothing to say.
Limitation, if the deed was void, then in limitation.
Very understood.
The deed is void. That's why I was telling you.
It's void ab initio because no consideration passed, and you are a third party to the deed, and you are taking that point.
It's deed is void. I cannot seek for cancellation of the deed. That's why the declaration has to be sought.
Nothing. This is one of the first steps, rare first step is where we can decide right now. Now we understand why you didn't grant stay.
No, your lordship initially granted stay.
Thereafter, looking
at granted stay, then looked into the documents and saw that we were wrong.
Very well.
Consideration pass করার মা জীবনের লাইফটাইম মা কিছু বলে যায়নি দিয়েছে সে কিছু বলেনি তার মেয়ে এসে বলছে আমাদের
and my lord, the settlement
জিজ্ঞেস করুন yes my learned brother is asking
how long was she alive after the execution?
My mother expired in 1995, February 1995. Deed was executed, my lord, in 1992.
3 years.
And in between, there is a rectification deed also.
Oh, there's a rectification deed also.
His husband's right was reserved.
The husband was subsequently given a right.
That's why settlement. That's why the nomenclature settlement.
Not here. And I did not know, admittedly, I did not know about this thing till that criminal
case. So you also challenge the rectification deed?
Yes, yes. If the principal deed goes, my lord, automatically the subsequent thing goes. Because my lord, my
principal deed remains, by the same logic, the subsequent deed also remains. So no case.
Lord, my father is also.
We are dismissing the appeal. We are dismissing the appeal. Cite whatever judgment you have to.
Lord, I will be cite. I will be. Lord,
will be.
No,
I am citing or
yes,
nothing.
I am. Lord,
yes,
I was. Lord, I was on the issue of, Lord, that this is not a family settlement. This cannot be construed as a family settlement.
Whatever it is, it's a deed of transfer. The owner transferred her property to to other parties, and it's a registered deed that is sufficient for the court.
Lord, registered deed
Nomenclature is entirely immaterial, Mr. Kormukar.
without a passing of consideration. I am on that.
You are nobody to take that
Some
point.
kind of consideration.
Mother was alive till for 3 years after the deed, as
3 years
my
after the
brother
deed.
rightly asked. She did not prefer any challenge on the ground of consideration. You are coming up and saying you are not in a position to know even whether she got a consideration.
There
How
might-
do you know? How do you have direct
It
knowledge?
has to be written in the. It has to be written in the deed.
Did not be.
That has to be written in the deed. Not
Void on the ground of non-passage of consideration, Mr. Kormukar, can only be taken by the transferor, not by a third party. Not by a third party.
Lord,
Let us see what the court has held about it.
kindly will not takes the impugned order one, degree one.
Yes.
Page 69, Millard, of the application.
61. Non-passage of consideration, where has it been discussed?
That has not been treated.
No, not.
That was not taken in the plaint.
It was presumed that the deed is registered, so Millard, it's a valid deed.
No, in the plaintiff challenge that there was no passage of consideration.
Millard, in the plaint, the plaint case is Millard, it is void ab initio.
Because you want it.
May I
Because
please
you want it to be void.
Is the plaint, Millard?
Let us see the plaint first.
Millard, page 44.
So, Kormukar, you will get us framed someday for being abusive in court. Grandfather, uncle, adequate, yes, got married, moved to in-laws, to a twilight year. Lost her mental capacity. Excellent. Because she gave it to someone else.
That's the court disbelief because subsequent deed of rectification.
Your client has lost her mental capacity in filing the suit.
But should have challenged earlier.
Should have challenged earlier, only physically and mentally unfit. Your mother.
Lord, kindly
She was
take.
unfit at the time of giving birth to you, physically. But not otherwise. No, Mr. Kormukar, no. Only case is that she was suffering from cancer, not mentally fit as she was suffering from cancer. You choose your costs, Mr. Kormukar. We'll permit you to, we'll give a range. Within that, you fix it. Obviously, you choose a lower one. We'll have an open bidding on the costs to be imposed.
May I consider that and come back to.
No, don't consider. Don't. We'll consider for you. We are deciding the appeal right now. Since the questions involved in the appeal and the application are similar, we are taking up the appeal for hearing by dispensing with other formalities, as both the parties are before us. So the next para, the appellant filed a suit challenging a purported deed of settlement executed by the plaintiff stroke appellant's mother, Srimati Rama Chatterjee. The deed was alleged to be void in view of the executant, Srimati Rama Chatterjee, being physically and mentally unfit as she was suffering from cancer during the relevant period. Next para, the learned trial judge dismissed the suit on 2 counts. First comma, the plaintiff derived knowledge of the suit in the year 2004. In the year 2004 from a criminal proceeding, whereas the suit was filed only in the year 2009. Apart from holding that the suit is time barred, comma, the learned trial judge also proceeded to hold that the plaintiff failed to prove her plaint case. Next para, upon hearing learned counsel for the parties and going through the materials on record, comma, we find that the learned trial judge was correct, was justified on both grounds. Full stop. Next para, the appellant argues that in view of the deed being void ab initio, comma, the question of limitation does not arise. Full stop. However, comma, we are unable to agree with learned counsel for the appellant. Full stop. Learned counsel for the appellant has argued before us that no consideration passed for execution of the deed, comma, nor was the impugned deed couched in the form of any of the transfers as contemplated under the Transfer of Property Act. Full stop. However, comma, in whatever manner a deed is couched, comma, in the event there is registration and proper payment of stamp duty, comma, there is no particular form prescribed for a transfer deed. Full stop. In the present case, comma, it was couched as a deed of settlement because certain rights were reserved for the husband of the transferor. Full stop. That apart, comma, since the deed was admittedly a registered one, comma, there was no question of any doubt about the execution of the same. Full stop. Next para, in any event, comma, the learned trial judge rightly held that the plaintiff appellant abjectly failed to prove her case that the transferor was mentally or physically so unsound during the relevant period that she was not in a position to execute the deed of settlement, impugned deed of settlement. For sub next para, the case of non-passage of consideration is now argued from the bar and was neither argued in the court below, neither argued in the trial court, nor finds place in the plaint pleadings. Full stop. In any event, comma, non-passage of consideration cannot be set up by a third party to a deed, comma, particularly since the transferor herself, comma, the mother of the appellant, comma, did not take such point during her lifetime, despite her being alive for about 3 years even after the execution of the deed. Full stop. Next para, thus, comma, the ground of limitation also gains currency, comma, since the deed not being void ab initio from any perspective, comma, the plaintiff, comma, having knowledge of the execution of the deed in the year 2004, comma, ought to have filed a suit for declaration stroke cancellation challenging the same within 3 years thereafter. Full stop. Having not done so and having instituted the suit only in 2009, comma, the suit was also palpably time barred. Full stop. Hence, comma, there is no merit whatsoever in the appeal. Accordingly, FAT 181 of 2025 is dismissed on contest, comma, thereby affirming the impugned judgment and decree
24th December 2024.
Yes, dated December 24, 2024, passed by the learned civil judge, senior division, third court at Howrah, district Howrah, in titled suit number 113 of 2009. Push up next para. Consequentially, can 1 of 2025 is also disposed of. Push up, there will be no arrest to cost. A formal decree be drawn up accordingly. Appropriate order, this application is still pending. That is can 1.
That is can 1.
No,
Can 2, there's one can 2.
Can 2 is for appropriate order.
Can 2 is also disposed of. Can 1 and can 2. Both are.
Obliged not for giving me a hearing.
No, sir. Thank you. Thank you for being reasonable and not continuing. Yes.
47 and for the appellate.
Yes.
The court says that the trial court decree is defective.
Oh, acha. Can you rectify that or it has to be sent down? Let us.
According to report of send down.
The informed degree is wrong date of
But
judgment.
without what is defect, nothing is.
Yes, it has been recorded that impugned degree bears a wrong date of judgment. So that we can do after hearing you. What is the application for?
Application for stay of operation of the order.
What is the decree about?
Decree was divorce. Suit filed by the husband and ultimately.
Decree has been granted. There is no scope of stay because it's a judgment in name, but will restrain the husband from remarrying.
Remarriage.
Has he remarried? Do you have any idea? You don't have any contact with your client as it appears from you, from your expression.
Maybe.
Maybe.
He married
Acha,
to
very
me.
well. Will restrain if not already. There are certain defects in the decree of the trial court for which the records are required to be, for which the decree is required to be sent down. Full stop. However, in view of the urgency pleaded, we take up the application for stay for hearing. Full stop. Next para. The present appeal has been preferred against a divorce decree passed in favor of the respondent husband. Full stop. Unless a restraint order is passed, the appeal is at the risk of being rendered infructuous. Full stop. Although we decline from granting any stay in view of the judgment being in the nature of a judgment in rem and having wider ramifications, the purpose of justice will be subserved if the respondent husband is restrained from contracting remarriage. Accordingly, the respondent husband is restrained from contracting any remarriage during pendency of the application unless such remarriage has already been contracted before today. Next para, such injunctions shall continue till the disposal of the present application. The petitioner shall serve a copy of the application on the respondent indicating that the application shall be listed next for hearing in the monthly list of December 2025. An affidavit of service shall be filed on the next occasion by the learned advocate for the appellant. The decree of the trial court be sent down in the meantime for the purpose of carrying out the necessary rectification.
After arrival of the record, liberty given me for hearing. For hearing, liberty, I am paying liberty to hear the matter after arrival of the record.
No, that we cannot do because the decree has to be corrected first. We cannot pass those directions, that's why. First, let it be corrected and come, then at the time of disposal of the application, we'll pass all out.
I am ready to do this.
For the appeal.
Yes.
Here the appeal was admitted, but the connected application on that day, it was not containing the proper averments. So your lordship was of the opinion that your lordship was pleased to admit the appeal, but given me liberty to file the application. I filed the application on the last occasion, that is on 17th September.
Yes.
There was a direction to serve the copy. I have served it, my lord.
File the application means you had already filed an application.
My lord. Lordship, your lordship was pleased to pass the order on 10 June.
What did you do? Reject that application?
No, that application is appearing today.
No, you said it was not in form or something like that, misconceived?
Can 1 was disposed.
Can 1 was disposed of since there is no scope for granting stay for all
appropriate injunction application, leave was given.
Yes.
So you have filed that appropriate application. This Can 2 is a fresh application.
Yes.
All right.
Fresh application, and
your suit has been dismissed.
My suit has been dismissed.
So therefore, there was no scope of stay.
Yes.
Very well. Here you have averred that they are trying to sell or something like that.
Yes, my lord. Here in the application, lordship, kindly come to the copy of the application. Here I have averted.
What was the suit for, Mr. Chatterjee?
This was suit for lordship permanent injunction on the sale because I entered into an agreement for sale. They promised me
it was
that
for
they will
specific
sell
performance or
specific
what?
performance. And then your lordship was pleased to observe it upon relying on 45 section proviso to section 45 of the stamp, the Registration Act. And here,
where have you alleged that they're trying to transfer or change nature character in your application? We gave you the liberty.
Lordship, this one, paragraph 14.
Read it.
Paragraph 13 and 14. Lordship, 13. The petitioner plaintiff further submits the attitude of non-performance on behalf of the defendant. Respondent made no room for disbelief that he is denying and interested to deny the right, interest, and petitioner plaintiff has acquired under the valuable lawful agreement as made between the parties. Naturally, if the respondent defendant would invet the right interest of the petitioner's plaintiff as acquired by way of execution of the sale, and on payment of rupees such and such out of total consideration of 30 lakhs by taking resource of unfair means and then unwanted invasion would not be compensated money in order to afford adequate relief, the petitioner's plaintiff. Thereafter, petitioner's plaintiff further submits that as
What
per
sort of complex sentences are these? Bypassing the statutory obligation as required by law, violence. There is not a single averment that they are trying to dispose of. One sentence would do. They are trying to dispose of and change the nature character. Apart from that, you have said, read paragraph 14. You
Paragraph-
submit that as per principle of law, respondent being vendor shall no right and entitled to get any privilege to deal and sell with the property. As per law, we'll decide that in the appeal. But
here-
you have not even about a single
the,
sentence.
the last paragraph, last line, Lordship.
Read it. Where is the verb there?
Yes.
That they are trying.
No, the trying is missing. That it's the
Nothing.
the interest
But
sell,
from the
alienate the
reasonable-
suit property.
See,
in
after you
favor
go
of
up to there, you reach the shore, but fail to dive. You say, but from the reasonable sources, plaintiffs got knowledge that in existence of the said agreement and without execution of said deed in favor of petitioners, rather bypassing the statutory obligation as acquired by way of the said agreement and on gross disobedience, violence of the terms and conditions of the agreement, the respondent defendant in ill motive and ulterior intention to
Yes,
cheat
ma'am.
and deprive the plaintiff, their interest sale alienate the suit property in favor of third party. Anyway, we'll read that. In view of the present appeal having arisen out of the dismissal of a suit for specific performance and questions of both fact and law being involved, we are of the opinion that a prima facie case for hearing the appeal on merits have been made out. Also from the application for injunction, it prima facie appears that the balance of convenience and inconvenience and irreparable injury factors lie in favor of grant of injunction. Accordingly, the respondent opposite party and his men and agents are hereby restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in favor of third parties and or changing the nature and character of the suit property in any manner till disposal of the application. The petitioners shall serve a copy of Can 2 of 2025 on the respondent stroke opposite party, indicating that the application shall be listed in the monthly list of December 2025.
Lordship, this is served, Lordship.
We directed you to serve. How
Yes,
could we?
on the last occasion, the matter appeared before the Honorable Division Bench of Honorable S. Sen.
As you have already served. Good service effective.
Yes.
So file the affidavit of service first.
Yes, madam.
Check up whether he has been served.
Item delivered.
Delivered. তাহলে ওখানে till disposal of the application না করে অনধিতা till disposal of the appeal করো। Till disposal of the appeal. আর সার্ভিস অফ কপির জায়গাটা পুরো বাদ চলে যাবে তার। Shall serve copy পুরোটা বাদ। তার বদলে হবে the appellants shall put in postal costs and requisites for service of notice of the appeal on the respondent within a week from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for hearing as and when the same is made ready for hearing.
Grateful, madam.
Next. ওই শেক্সপিয়ারের মতো। Yes.
My lord, kindly allow me 10 minutes, my lord, to go through the brief at least once, my lord.
Fair enough.
This matter has been perhaps admitted. Mr. Parthor Pratim Rai appeared in this.
No, this is the injunction application which is appearing. Application is appearing, not admission hearing. You take your breath. We give you the 10 minutes.
Much obliged.
Fair submission. Thank you. পাঁচ ওভার থাকে। নিঃশ্বাস ফেরত পেলে তারপর বলবেন। ওর দিকে খেয়াল রাখুন। Yes. Blue dot দিয়ে সম্বন্ধে দিয়েছে। None appears for the parties at the time of call. Let the matter stand adjourned for the day.
Yes, sir. For the appellant, my lord, Mr. Shoptang Basu and Mrs. Usha Maiti is leading me. My lord, what happened, my lord, on the earlier occasion, your lord is directed to, my lord, supply the records from the
supply the
records from the BLRO, most probably. That record has not come.
Who will supply? They will supply.
They will supply. They will produce the record before your lordship.
Haldia municipality is the matter, my lord.
The development authority, state is the responding authority. Mr.
You are neither of you are appearing for the state.
No,
No, they are not appearing. State will, the record has not come.
I can see the last order, one file, there is a direction.
They filed the deal. ওখানে রেখে দিলে হবে। ওটা যাচ্ছ।
They directed the registry.
Register
Bring the registry.
রেকর্ডস না না এই ডব্লিউপিটা আনার কথা ছিল তো একটা ডব্লিউপি এই দেখুন অর্ডারটা লাস্ট অর্ডারটা for 18/20/25, the records of WP number 9114 within bracket W of 1998 have not yet arrived or tagged with the present file. Full stop. The office is directed to take immediate action on the previous direction and ensure that the records are brought and tagged with the present file within a fortnight from date. Full stop. The application shall be listed next on November 17, 2020, November 24, 2025. রিপিটিশনের কিছু একটা ইনস্ট্রাকশন আছে না দেখে করা যাবে না বলে আগে এই 52টার পরে আবার পাসওয়ার্ড ম্যাটারটা লাগে
But I appear for the
Yes, Mr.
applicant.
Rai.
That on the last occasion, your lordship had directed us to serve copy, my lord. It is solved and delivered. But your lordship had been
My lord, I am for the state, my lord. Mr. Dotto has been instructed to appear on this matter, my lord. My lord, we haven't.
Subrata Dotto?
My lord, Dipanjan Dotto, my lord.
Acha.
My lord, we haven't received the copy, my lord. My lord.
That's the state's problem, not Nestle's problem. State is appearing in the matter.
But it's a food safety officer.
Sir.
He is an agency of the state.
So how soon can you obtain the copy?
There is a stay order within 10 days. We shall get the final.
You are enjoying an order, sir.
I am enjoying an order up to the 15th of November.
We'll extend that till disposal of the
Great,
application.
great.
The state seeks an adjournment in the matter. Sorry, the respondent seeks an adjournment in the matter. So let the interim order stand extended till disposal of the application. First of the application shall next be listed in the monthly list of December 2025.
Great.
Please ensure that in the meantime you get the files and all. After line at affidavit of service you are filing today, Mr. Rai?
Yes, yes.
Affidavit of service filed today. You are getting 4 weeks time. Obtain whatever you have. Pass over matter. Yes. Sir. Please. An adjournment was sought in the first call. None appears for the parties at the second call. Full stop, let the matter stand adjourned for the day. The record third. Document 53 ever. Application update গুটিয়ে গেছে application update গুটিয়ে সিভিল গুলো মোটামুটি গুটিয়ে দিয়েছি ও রিড গুলো হয়ে গেল
Lordship, I'm just praying for not today, Lordship, on behalf of Mr. Supratim Dhar, senior advocate.
You're for the respondent or the appellant?
Appellant.
On the prayer of the appellant, on the prayer of the petitioner, the matter is adjourned for the day. Yes, next. Yes, same prayer. Same prayer. Same order.
We have a respondent, Lordship.
Oh, acha. On the prayer of the respondent, the matter is adjourned for the day.
I'll invite Mr. Vishwanath Chatterjee. He is on the way. I'm seeking for a short pass.
Respondent. There is no appellant. None appears for the appellant, although the respondent is represented through counsel. Let the matter stand adjourned for the day. Give your name, ma'am. Your name. None appears for the parties. Adjourned for the day.
My lord, seeking
for the respondent, my lord.
my lord, seeking adjournment for the day. Advocate on record is really ill and could not come.
Really ill means what is unreally ill?
He could not come to court and
Then really ill. On the prayer of the appellant, let the matter stand adjourned for the day.
Grateful, my lord.
58, 59, my lord, Group 8 appeals, my lord.
Group 8?
Group 8, my lord. We'll
Thank
miss
God.
our opportunity to assist you.
No,
Lord.
no, it's our opportunity to release. Let the matter, in view of lack of determination, comma, let the matter go out of the list with liberty to the parties to mention before the appropriate bench having determination. Thank you.
Remain grateful. My
None appears for the parties. None appears for the parties at the time of call. Adjourn for the day.
Your Lordship, I am appeared on behalf of Union of India. My senior is on his legs.
Appellant is also not there. Petition is also not there. Anyway, কিছু order record করে pass not today করে we are not recording any order not today
Grateful, Your Lordship.
কোন order record করতে হবে না গ্রুপ 8 আছে গ্রুপ 8 গুলো কেন আসছে determination let the matter go out of the list with liberty to the parties to mention before the appropriate bench having determination for inclusion in the said list দেখে নিন তো গ্রুপ 8 কিনে দাও দিন কোথায় ফাইলটা
Yes, my lord. Item number 60 was a group 8 matter. My lord, the board was not.
board was not functioning.
Was not functioning, my lord. 60 and 61
বলবে তো সেটা
group 8 matter.
board function করছে 60 was also তাহলে 60 টা একবার
60 and 61.
60 61 একটা অর্ডার তাহলে রেকর্ড করুন this is also yours 64
No, my lord. No.
60 61 তাহলে একটা অর্ডার রেকর্ড করুন ওই যেটা বলবে in view of lack of determination let the matter go out of the list with liberty to participation before that 60 61 then please inform your other side if somebody was appearing because if somebody was watching we don't know
My lord, this has been listed, my lord, at the instance of the respondent. They had mentioned the matters. My lord, we
So
will
then please
inform.
just try to
We
just-
will inform, my lord.
অর্ডারটা থাকবে 64 টা দেখছি 64 না এটা ল্যান্ড রিপোর্টস এটা আমাদের এটা কোন অর্ডার রেকর্ড নট টু রেকর্ড অর্ডার এতগুলো করতে গেলে টাইপও করতে হবে সইও করতে হবে আর বোথ সাইড না থাকলে নয় ইয়েস নট টুডে সেম ইয়েস মিস্টার পাল
Lordship, before vacation, your lordship passed an interim order, lordship.
that is still subsisting
Lordship.
till disposal of the application
Lordship.
you are for the
Lordship.
respondent
Lordship, I am for the petitioner.
Ms. Rai you are for the respondent Mr. Rai is in the matter
Yes, yes.
he's coming
Yes, he's coming.
Lordship, I have challenged the order.
Yes.
Page 117, lordship.
Oh, this is an intercode appeal.
Lordship.
Oh, these are intercode appeals. Yes. What was the nature of the order, Mr. Palan? Yes.
Lordship, lordship, can you tell lordship the last order, your lordship?
Ask. What was your application for, writ petition for?
Lordship, Lordship, writ petition, both sides filed the writ petition. Lordship, the private respondent also filed writ petition, and I have also filed writ petition. Their contention is that the pathway we are using, that is unauthorized pathway, that is their plot of land.
So what is the relief they sought?
Lordship,
Recording of
Lordship,
correction of
their
recording.
prayer was that I have dumped something over that pathway to release this everything and not to allow us to use that pathway, Lordship.
How can a writ petition be maintainable for that?
Lordship, that is my first contention I have raised, Lordship. I will turn the order, Lordship, that is the civil court jurisdiction, absolutely.
And what was your writ petition?
Lordship, my writ petition is that we are using this pathway for since long, and so the petitioner is not the absolute owner of the
So
property.
you also sought a civil relief before the writ court.
That is done.
Both of you sought civil relief, Mr. Rai.
Lordship, that is as Lordship, the order
This
passed.
client, then you can take the call. No, both of you apparently sought civil relief, civil court relief before the writ
Lordship,
court.
in appeal, Lordship, I have briefed, Lordship.
Mr. Pal, you are enjoying an interim order.
Lordship, 30th November.
30th November. We'll keep it, we'll just make it not today only.
Lordship.
On the prayer of the respondent, the matter is adjourned for the day.
Lordship.
এই পড়ে যাবে নি দীপঙ্কর তুমি এক সাইড থেকে নাও ওনাকে এক সাইড থেকে নিতে তাহলে জিনিস ইকুয়ালি ডিস্ট্রিবিউটেড হবে ফাইলগুলো নট টুডে Yes.
Lordship, short pass over.
No, refused. Start the matter. What is the brief?
Lordship, I'm not.
You are what? We can see you are.
Lordship, this is not my matter, Lordship. My also not.
Your
my
senior is there.
senior
Where are you
is-
asking for? Your senior is there.
Yeah, my senior is there, but
You are his chamber junior.
Lordship, this matter is another person's. My senior is arguing counsel.
The file should be in the court. Why is the file not in the court?
File is.
You should be responsible for your chamber senior regarding matters briefed by others also.
Lordship, my
Chamber junior means that. Who is your senior?
Arup Krishna Das.
So you should be, I mean, not ready in his matters, but the file should be there. You should ensure that.
But my log.
FAT 73, I have been instructed to appear on behalf of the
69.
appellant. My lord, yes, item number 69 is
Oh, there are two matters.
FAT 73 of 2020,
Yes,
Day versus Subroto Day.
Yes.
That
You
has
have been instructed to appear for the appellant.
Yes, my lord.
Sorry,
You are
Lordship.
confusing
Lordship,
matters.
confusing.
Your matter have been dismissed for default.
Lovely things, sorry, Lordship, confused.
No, you check up which matter
69, Lordship, in the another.
in another court.
Sorry, Lordship, sorry.
No, no difficulty. Yes. Yes, din file.
This
না নিষ্কৃতি নেই, আপনি ফাইলটা দিন।
appeal is directed against a decree for dissolution of marriage, my lord. During the pendency of
Appearing for the first time or directed, copy service directed?
it was directed, paper books have been filed as per lordship's last order, my
Oh, this is a hearing matter.
Yes, my lord.
We start the hearing.
My lord, the only thing is the husband who is the respondent,
Yes.
he has remarried during pendency of the appeal. That is an
Want to
admitted
withdraw the
position.
appeal or
No, my lord, the question of permanent alimony
Permanent
still remains. Now, lordship, if
we'll
you
send it to mediation then?
my lord, we have tried mediation once, it has failed. So if
Just
you
one for formal mediation.
no, my lord, only settlement between the parties.
Parties mediation, there are trained mediators, so they may try it out. Because if it boils down to that, it's a fit case for mediation.
And also there is a flat in the joint name of both the parties. The husband has rented it out. He's receiving some income.
You
by
can have a
putting it on
composite
rent.
resolution, but
Well,
first you have to find the file. Let us
But
wait for
I have already prepared an application for payment of permanent alimony. If lordship so directs, I shall file it formally. It can be decided by this
this
honorable
challenge is
bench.
against a divorce decree.
Divorce decree, my lord.
You have filed it.
No, my lord, it's ready. I will file it day after tomorrow, lordship. So
Very
any day, lordship.
Learned counsel for the appellant submits at the present, learned counsel for the appellant submits that the appeal has been preferred against a divorce decree obtained by the respondent husband. Stop. Learned counsel candidly submits that the respondent husband has apparently contracted another marriage in the meantime, and the dispute might boil down to the fixation of permanent alimony. Full stop. Next para. The appellant is in the process of preparing an application for permanent alimony and seeks some time to file the same. Full stop. Accordingly, let the matter stand adjourned till November 17, 2025, when it will be listed under the same heading, full stop. Liberty is granted to the appellant to file an application for permanent alimony in the meantime and mention the same for inclusion in the list along with the current matter. Put some next para. An advance copy of the application shall be served on the respondent, comma, either directly or through the respondent's advocate in this court in the meantime, and an affidavit of service to that effect shall be filed in court on the returnable date.
I'm deeply obliged, my lord.
ফাইলটা পাওয়া না গেলে তো ফাইলটা কোথায় এখন পাওয়া যায়নি? সেটাতে তো ফাইল থাকবে না তাহলে নাকি? একটা ফাইল নেই কেন? মাঝখানে ফাইলটা কোথায় যাবে? এই এক্ষুনি ফাইল দেখো, একটা মাঝখান থেকে ফাইল কোথায় যাবে? টেবিলের তলা বা আমাদের চেয়ারের তলা ফেলে নেই তো, দেখে নাও। দেখে নাও কোথায় 69 আগেরটা। Yes, you are appearing.
No, Milord.
You're not appearing.
No, Milord, Mr. Mukherjee is appearing. Shottam Mukherjee. He has not.
Mr. which Mukherjee?
Shottam Mukherjee, Milord. He is appearing on behalf of the appellant, Milord. He has not.
We're making it not today, just. We're not recording any order. Not today.
Number 21.
Same, not today. না থাকলে not today.
Item number 73, I have been appointed by the Legal Services Authority on behalf of the respondent wife, but
Yes.
no one has contacted, Lordship.
So when should you keep it? Tell us. No one has contacted me with the brief.
No, the paper book has been served by the appellant to the legal aid services. They have handed over the copy of the paper book to us. We couldn't contact the client.
What should you do? Tell us. Legal aid matter, we should give some laxity. So you try to contact. We'll give you 2 weeks time.
Lordship.
Learned counsel, you're for the appellant.
Respondent.
Learned counsel appearing for the respondent submits that the brief has been allotted to her on behalf of the respondent by the Legal Aid Services Authority, and she does not have contact at present with her client. So accordingly, to enable learned counsel for the respondent to establish contact with her client through the legal aid authorities, let the matter stand adjourned till November 24, 2025.
Grateful, my lord.
Item number 74.
Not today.
75.
Same.
76. 77.
Same. Not today.
79. 80. 81 and 82.
এগুলো সবার পরের মান্থলি লিস্টে চলে যাবে, হ্যাঁ, যেগুলো কেউ আসছে। ইয়েস, কল করুন।
83, Your Lordship. 83
You're appearing,
the
83.
appellant, Lordship.
Start the matter.
Lordship.
Appeal, ফাইলটা দীপঙ্কর কোর্ট থেকে বেরিয়ে কোথায় আছে ওটা? Files
Lordship.
are coming.
Lordship, it is, I'm for the respondent, Your Lordship.
দুদিন তো হয়ে গেল, তাতেও কেন হচ্ছে না? অনেকদিন আচ্ছা।
Lordship, this is the appeal filed by the state respondent, Your Lordship.
Right.
They have on the last 2 occasions, Your
For
Lordship.
the
I am for the writ petitioner respondent.
all right.
Your Lordship, this order is passed on 7th of March 2014, when there was a direction passed that the land should be returned to the petitioners, and the encroachers who were encroaching at that point of time, they should be removed from the petitioner's land and they should be rehabilitated in some other land.
Right.
Now when the
in this appeal.
Lordship, I'm the writ petitioner respondent. This is my land.
No, the appeal is theirs.
Lordship, the appeal is of the state. The
What is the
state,
ground in the appeal?
the DM, your Lordship, thereafter the BLLRO. Now, your Lordship, the ground has culminated, your Lordship. The appeal, when it was appearing before Honorable Justice Boshak, your Lordship, they've admitted that we are only aggrieved with that we are not aggrieved with the part of the appeal. There was a cost which was imposed since a wrong statement was made by the BLLRO. Accordingly, that cost part was they were exempted from paying that cost part. Thereafter, they have admitted, filed compliance report that now we are in the process of
removal of
them. We have removed 20.
So
we are
what remains
supposed,
in the appeal then?
nothing remains in the appeal, your Lordship. The contempt was
We'll
the
do
co-
this. We'll do
Lordship.
this, Ms. Ghosh. We'll record that none appears for the appellant. We'll ask you to give a notice to the
Lordship,
advocate for the appellant to put it on Monday.
Lordship.
And we'll record in our order that if they don't appear on the next session, we'll just dismiss for default.
Lordship,
We
Lordship.
cannot dismiss on merits.
No, no.
And then we can record your submissions also. for this.
Lordship, Lordship.
At the time of call, although the respondents are represented through counsel, none appears to argue the appeal. Full stop, next para. The learned advocate on record for the respondent shall give a notice to the learned advocate on record appearing for the appellant, indicating that the matter shall be listed under the heading to be mentioned on November 10, 2025. Full stop. Learned counsel for the respondent submits that since substantially the impugned order has been complied with, the conspectus of the appeal might boil down to the costs imposed on the appellants. Full stop. As such, since there is a chance of the appeal, the conspectus of the appeal having been rendered brief, we choose to keep the matter under the heading to be mentioned. Full stop. Next para. It is, however, made clear that in the event the appellants do not argue the appeal on the returnable date, the ex parte orders may be passed in the absence of the appellants.
Grateful, my lord.
Next.
Item number 84.
ফাইল আছে, এটা ফাইল আছে নেই, দুদিন ধরে ফাইল আসছে না কেন?
I am for the petition.
What is the matter about?
This is my matter about the land was, they said the land was acquired. And challenging that, so our contention, the land was not acquired because no award was given, paid to the landowners. So, against the judgment passed by the Honorable Justice Bhattacharya, we have paid for appeal. And also filed.
Have you got a, you don't also have a paper?
Both
of us don't have a paper, then what?
Is the matter
It will be not today then.
Well,
not today. If you have an extra copy, we can start the matter with the. Anyway, not today.
Fine.
Item number 86 is Group 8.
Group 8. In view of lack of determination, let the matter go out of the list with liberty to the parties to mention for inclusion before the appropriate bench having determination. Yes, sir. Group 8 কিনা সেটাও তো ascertain করতে পারছি না ফাইল নিয়ে বলে। Not today করে দেন। ওকে আনতে গেছে দীপঙ্কর?
I'm for the Union of India.
You are the appellant?
No.
96, I'm for the
Respond.
95, 96 connected matters.
No, 97.
This is 97. The other side is in any event not there. So
Let it remain as not today.
yes, only not. We are not recording any order. We are just
98.
same.
Not today. Not today.
No, in any event, we are granting not today. The file is not today.
100. 101. 104. 210. 112.
112, I am for the petition number 8
Not today. Not
113.
13, your lordship, I'm praying for not today.
not.
Yes, 1142, 117.
You are for the appellant.
State respondent.
Yes, we are, my lord. State respondent.
Who is for the appellant?
My lord, 117, I am for the respondent.
No, we are. It is state's appeal. First one.
Oh, state's appeal. Do you have an extra copy? Then you can start.
Sure.
Not today then.
118. 119.
For the state response.
120. For the state.
One side will not do.
121. 123. 124. 125. 126. 127. 128 to 129. 130. 131. 134. 135. 136. 137. 138. 139.
139 for the appellant.
One side, no file. No file either side. Not today, Mr. Rai.
140 to 141. 142. 143. 144. 145 to 147. 148.
দেখে নিন ওদের ডাকুন মামলাগুলো ডাকুন ওদেরও ডাকুন দুটোই একসঙ্গে করতে
150. 150.
My lord, I pray for unconditional apology, my lord.
Accepted.
What? Item number 72, I am for the appellant. My lord.
What have you done?
My lord, I was not in the court, my lord. Whether it has been posted in the next monthly list, my lord, I am not sure.
That's some history.
My lord, kindly keep it not today.
We have passed our order, whatever.
My lord. My lord.
Passed. Whatever order we have passed, we have passed. We don't recall orders. Mr. Rai, yes?
My lord was pleased to
You have dismissed. You have passed over a matter.
Yes, yes.
That was called again, and we have recorded, and the second call also none appears. So, whatever we have passed, we have passed. But an order has been recorded. You check up that order.
My matter is 75.
75 must have been dismissed by default. Your matter by default those are dismissed by default.
Your lordship, kindly excuse me.
File a restoration. You check up the list. Check up the website. What is the order passed? If dismissed by default, file a restoration application. We'll definitely allow it.
So,
Yes, you have come here to smile all the way, or something. Add something.
this will be hard with the single bench, my lord.
That is why we were calling the matters, because most of the files are not here, but some are group 8 matters. That is the reason we were.
It's a remand. My lord knows the remand matter.
That's why we are calling all the matters. Although the files are not here, some of the matters people told that those are group 8 we are releasing.
And there, my lord.
No difficulty, no difficulty. But Mr. Rai, if it's a remand matter, when we take up the next day when you sit, because this is quite down in the list, we won't reach in normal circumstances. You just mention at the time of mentioning out that, and we'll put it as to be mentioned on Monday and release it. These sort of matters, if it's we don't have determination or something like that.
The remand matter, my lord knows.
Yes, just you reminded us on that. You just mention those matters on the next date when we sit. We'll put it as to be mentioned and we'll release.
As is,